And when the whole postmortem will start, who were the necessary stakeholders, who gave this approval? And that's why, and the expectation from these ethics committee is primarily from now change from an IP perspective to a generalist perspective. And our responses become very crucial because other person's jobs are at stake. So our problem within an organization from an ethical consideration is not only limited to intellectual property, although it started with intellectual property, but it will end somewhere else. So we have to keep on managing the risk from various different organizations and working within the organization, different entities based on different jurisdictions, different teams across altogether. So that's why, like for me, it's purely black and white in terms of what different people are telling, and then bringing all together in one room. And this is your problem. This is your problem. This is your problem. Please talk and find a solution so that we can go as a. But as you all know, it never happens because you are in different jurisdiction, different time zones, different organization members involved. That's some of the issues what we come across. And one thing more I would like to touch upon is our communication with practitioners. Say, for example, I'll reach out to you, hey, Vasundhara, like, what's your opinion about this? And you will give me an honest opinion. Sort of, there's a risk. This is the managed risk position, and this is how you can proceed. Now, if it is going beyond 2 pages, no one within an organization will read. So Vasundhara has given me her experience, but it's my job to, kind of concentrate in like bullet points to communicate internally, because that's one of the biggest problem. And if everything falls back, then if people will come and tell, okay, external counsel has advised us. But for me, it's become more important as the in-house perspective that whether I have carried forward those checks and balance provided by the practitioner within the organization in the correct fashion or not, whether I have highlighted the red flags, whether I have given the way outs in those 5 bullet points. And whole job boils down to creating those 5 bullet points and managing the risk. And second, again, like for example, if we as an in-house counsel found a loophole or find of a suggestion to be given to an external practitioner, then also there is a tendency within organization not to listen, because they'll always fall back, okay, they are more experienced, they have exposure to multiple clients, they have exposure to different things, so let us fall back on their opinion. And it's most of the time in-house lawyers' opinions doesn't matter. It will only matter when things will fall apart. Then again, we have to reach back to the practitioner, make it a collaborative approach, bring a business use case to the organization, and manage not only business but considerations and also ethical consideration involved, because different teams are involved here. So that's a different ballgame altogether for us working in an in-house environment vis-a-vis an IP perspective. So that's a good discussion on like from John's perspective, Vasundhara's perspective, in-house perspective, and we'll probably pause for a minute or so to take questions before we go ahead with the next topic or discussion regarding best practices for IP professional. If we can take questions after the session as well. Yes, please.
Thank you. My name is Rahul. I practice IP law. I just wanted to ask, from your experiences, how do you handle conflict of interest when it is an issue conflict? In one case, as a practitioner, you advising a claimant on a certain right, and you're advising a defendant on the same issue on the other side. As an IP practitioner, how do you balance? Because on law, you can't fiddle much. You have to draw lines.
Yeah.
Thank you.
Yeah. Thank you. And this is what our next topic leads to, is conflict of interest. So we'll probably frame similar question in our like key issues. Vasundhara, you take care of it while handling conflict of interest situation while representing different clients. I can go ahead with the conflict of interest from an in-house perspective. Yeah. So I'll give you an in-house answer. What do you mean by conflict of interest for me? And probably Vasundhara can give a from practitioner perspective. For conflict of interest for an organization is a conflict of interest from different team organization. One team within my organization can give something back to an end customer which another team has not approved of it. And that's why managing the risk position. But probably I'll come to that later, because this question is more from a practitioner perspective, and probably Vasundhara, you can take that and we can lead the conversation to our side.
All right, thank you. We were supposed to talk about conflict of interest, but that's perfect. We're talking about conflict of interest, and that definitely arises in our world. And I'm not talking about only intellectual property. I'm talking about the broader scenario. In every aspect, as a lawyer, you do have the conflict of interest that you face in sometimes when you're representing too many clients. For me, as a practitioner, I would say it's important for a complete transparency and disclosure. And I make sure that before taking up a matter, I do have the consent of the client in terms of the intellectual property that they're disclosing. Apart from that, it's very important to understand in some very complex intellectual property matters, till the time you're not infringing on a patent or a trademark or a copyright of the other organization that you will be representing, that's perfectly fine. That's a gray area that you have to, that you face on a regular basis. But in terms of conflict, if it's a direct conflict, then you usually avoid taking up that matter for a certain period of time till the time the conflict is remedied, or it's you don't have the conflict any further. So transparency, extremely important as a lawyer, to be transparent and not to withhold information from your client in terms of if there is a conflict of interest. Secondly, having a broader range or a full spectrum consent from your client helps you in taking it forward. Other than that, I certainly advise other lawyers or people, or just general practitioners, that in terms of conflict, till the time it's a live conflict, you definitely have to avoid that matter. But if it's something which is not going to be, you're not supposed to entail that during your litigation, then that's perfectly fine to take up that matter. So it's very subjective in that sense. I mean, you don't have
my
a clear
question was
cut.
more on legal issue, not on the same issue, conflict on both sides. But you're, let's say, on an issue defending a claimant in one set of things, on the same issue, the
Then
defendant
you definitely have
legally
that.
there is, you're not bound by conflict of interest per
Perfect.
se. But then, how do you switch into different cases on different sides? And especially if you are now in India going before an IBD, which probably is only one judge or two judges. So he's seeing you standing on different cases, on different sides, on the same issue, taking different stands.
All right,
Is there an
perfect.
ethical issue there or not?
That there is a certainly ethical issue. All right, to answer it, I mean, that happens on a regular basis. You have senior counsels representing, Airtel, and then the same counsel is representing Vodafone. So you have you have conflict of interest on a regular basis. But till the time you're not hampering the first client, and the first client gives you consent to represent the other client, then that's a gray area that every practitioner has to follow. So there's no clear-cut answer to it, but I will say that's a gray area that has to be explored. But other than that, as a lawyer, I certainly avoid the conflict of interest happening and hampering the client that I've already represented.
Yeah, and I'll try to summarize the discussion here. Probably from both of your discussions, three things are coming into play here. One is entity-wise conflict, of course, as Vasundhara given an example of Airtel and Vodafone. Another is subject matter conflict, probably a live subject matter conflict having the similar issue. And probably third and the most important is the consent. And before taking consent, it's your duty and responsibility to inform your client that these are the issues. And even after that, if a client is disclosing a consent, and you have to clearly clarify on two parts, if I have understood from the conversation here, like title as well as subject matter conflict, then probably it will be ethically correct even you to ask the client, like, you want to give us a consent or not in these scenarios or not.
Can John share some American experience, how American law firms and ethics board handle? Is there an ethical issue here or not?
So, I mean, just anecdotally, what I hear from my friends that work in law firms in the US is there's a clear wall between the prosecution side and the litigation side, and then also between the different clients that are being represented. And they take great strides to maintain those walls and those that confidentiality between the different parties. So I don't know, again, specifically what the law or prohibition would be, but I believe there's one in place that would prevent the same person, same attorney from representing both sides of the coin in different matters. So, at the USPTO, though, we as employees are constantly conflicted out of certain matters. If we have spouses that work for a company, we're reviewing their application for patent or trademark on. So there are certain instances where we have to recuse ourselves because of conflict. But generally, you know, it happens few and far between, but it does happen.
Thanks, John. I think it's more subjective and has to be considered on a case-to-case basis. What's happening, and better to not draw any line around it, because everything is organic, like too many information flowing around it, and it's good in an ideal way the way it is as it is, in my personal experience, because it gives you necessary freedom to choose, and it gives the necessary freedom even for the clients to choose you or not. Yeah, so I think we have captured that particular, and I'll give you a more from an in-house perspective. Like, this is between customer and practitioner. There are conflict of interest for in-house as well. And as I mentioned, like, we have different teams in our organization, one sitting in Israel, one sitting in US. So we have a conflict of interest there. One team is working on a product line which is completely competitive, uh, which is completely should not be done because we have partnered for that solution for with someone else, and we are not sure what team in Israel is doing, and we have created Chinese wall, like you mentioned, that we will not be doing it, but still we are doing it. And once it is come back to the product review board for us, then only it's the time when we are becoming aware that should not have been done. Now energy is spent, resources have been spent, time of those individuals have been spent, and everything goes out, and we have to sit back and understand like whether it is allowed or not allowed. That's one form of conflict of interest while working for in-house attorneys. And there are conflict of interest within the legal department as well. And let me state very clearly, like, for me working, for example, a lawyer working in my organization has given some form of representation somewhere outside India, US. Those representations might not have been approved by an IP attorney working in my organization. And once I'm sued, then everyone fall back, okay, in the IP department, why these representations of non-infringement, allowing of marketing capacities have been approved. And then at that point of time, we again have to manage the conflict of interest within the legal team as well. So I think it's two sides of the same coin within the organization. And when that organization comes back to practitioner, there's different definition of conflict of interest in that perspective. Yeah. Perfect. Thank you for that question. Probably we'll move to duty of disclosure, which is primarily US specific, and there's a like very less parallel to be drawn. John, can you just give more highlights on like how to, what are the four corners of law for duty of disclosure in US?
Sure. So when we think about disclosure, ultimately it boils down to what is in the oath and declaration that is signed by the applicant at the time of filing for a patent or a trademark. And within the patents section, there is this duty of candor and good faith before the USPTO, and duty to disclosure is part of that. But just taking a quick step back recently, because we've been taking such a close look, not just within the USPTO, but across every branch of the US government with respect to artificial intelligence, how to ensure safe and that we use AI responsibly and it's safe and secure. And at the same time, we want to be able to support the technological advancements of AI as it develops more global solutions. But it made us, there were a lot of questions that you might be aware of, is that can AI be an inventor? Can they be an author, and all of these eligibility questions. So we came out just a couple of weeks ago with some updated guidance, and really that guidance says that our existing laws handle AI just like they have handled every other emerging technology in the past 200 years, from the sewing machines, the automobile, to the computer, and now to these advanced computing systems, AI, quantum computing. But we did one thing in this guidance. We clarified and basically we reminded applicants of their duty to disclose. And that's basically, they have to disclose in their application or in the papers accompanying their specification, all known information material to the patentability. And this extends to the inventorship and to the respective contributions of those inventors. So kind of going back to the AI aspect, but ultimately, whether you're aware of some piece of prior art that you're not providing to the office, if ultimately you were granted a patent and ultimately it was discovered that you were aware at time of filing of this material information and did not supply it to the USPTO, it could impact your the validity of your patent, and it could be withdrawn. So this duty to disclose is a big part of it. But the other thing we did in this guidance, which was very interesting, is we also reminded applicants of their duty of responsible inquiry. And that's something that, in my career, we haven't spent, it's all, I went back and looked, it's always been there, but it's not something we really focused on. We really focused on duty to disclosure because we want to look at, the information that the applicant knew at time of filing. But the duty of responsible inquiry is essentially to make sure that each party presenting a paper to the USPTO has a duty to perform an inquiry that it is reasonable under the circumstances. And this is primarily to ensure that any paper is not being presented for any improper purpose. And so again, kind of in the concept of AI, we don't want people making up names of or adding names of an AI, engine as an inventor. And so we reminded what those inventorship criteria are, and then we tied it to the existing duties to disclose and the duty for reasonable inquiry. So all of those are available on USPTO's website.
Okay, thanks, Sean. So primarily what's duty to disclose in US in summary is like everyone has to disclose everything regarding patentability before patent office, and it will overrule any kind of confidentiality obligation of that particular individual. We don't have similar provisions in India, but we have a couple of provisions, and probably Vasundhara can just highlight few of them, what's there in India vis-a-vis duty of disclosure.
Sure. Thanks, John. Thanks, Sora, for that question. All right. So we do have a duty of disclosure very much there in India, and that's being a common law jurisdiction. Most of the clauses or of specific intellectual property law. So I'm talking about patents, I'm talking about trademarks or copyright are similar in most of the jurisdictions. So US, EU, India, I think the common law, the big common law countries, and for that matter, even Japan for that matter. In India, we have the duty of disclosure definitely ingrained in our Indian patent law, where Section 8 specifically deals with disclosure. So prior to filing an application in India, if you filed an application somewhere else, by either be it the USPTO or you filed it with the EU, the European Union, the Benelux countries, you have to definitely have the obligation to provide all the disclosures. So as John mentioned, all the prior art, all the disclosure that you have relied upon when you filed that matter in the USPTO or the EU. You have the responsibility to give it across when you're filing the Indian patent. And for that matter, it's very important to understand that as a lawyer, we definitely have that responsibility to let the client know that all the disclosures are important. For them, it might be a very small disclosure. They might have relied on some specific invention that happened some 50 years ago, but still, I mean, if you have relied on that, you definitely have to disclose it. Prior art search is very important to follow, and that's a difficult thing to go about because a lot of times you overlook that, but that's something that you have to look at. And it's very interesting because when you go in for litigation in these particular scenarios, you have, it's still a gray area because the court comes up and says that if you're filing a specific claim which says that Section 8 is the part where which has not been followed by the client. The court has a discretionary power in that sense because in Section 64 of the same law, which says that it's a power upon the court to take it forward or to not take it forward. So I think the case that the landmark case that happened in India was specifically was Philips, and it wasn't a willful non-disclosure. It was something that was inadvertently done. So the court definitely looks at the intention of the party. So if you're willfully not disclosing what you've relied upon, then that's definitely something that you'll be barred. So your patent will be revoked. But if you've not willfully done it, if you've inadvertently misplaced a particular disclosure, if you've not mentioned just because you were not having that document at that point of time, then it's on the court's discretion to take to consider it, a gray area and to revoke your patent or finally to cancel your patent in that sense.
Yeah, thanks, Vasundhara. And the key word here was, I think, willful non-disclosure, and it might kind of act as a stopper against you, and it will grant the necessary right to the court to decide whether they should utilize as a stopper against you based upon the facts and circumstances of that particular case and scenario. Yeah, definitely. In the interest of time, we were like scheduled to discuss on unauthorized practice of law, neglect, dishonesty, which John has given a broad overview during the start, and probably we'll touch base very quickly on unauthorized practice of law, and probably it's very known to everyone that you should not be practicing if you are not a say registered patent agent, and we have necessary provisions for that within our own Indian Patents Act 129 to 132. And similarly, I think, John, you have mentioned that we have similar provisions in US and other jurisdictions as well, where this unauthorized practice of law is completely barred, and probably you can give some more examples on that part in this particular topic.
Sure, and I'll be brief, but basically I had mentioned this domicile rule 2019 on trademarks, where you now, in order to file a trademark before the US, we actually adopted an international best practice that you also need to file that application through a US attorney. So what we found happening is several countries that had these large trademark filing firms and engines that were filing in the US previously reached out to some US counsel, many US counsel, asking if they could use their credentials, and they'll just pay them a nominal sum of money, use their credentials so that they can file the applications through them. And this is something that violates our rules of conduct at the USPTO, because in order to, when you put your name as a representative of the applicant, you are saying that you've reviewed the application, you've done the best interest of the applicant and as their client. And for someone just passing the work through, and so we've seen instances where hundreds or thousands of applications were funneling through different attorneys. And so we've posted, so there's been many, just in 2023, we had, I think, 115 of these various sanctions where we've either temporarily suspended licenses, or given the egregious nature of the issue, they may have lost their license completely or turned in their license. But a lot of times we've seen instances where the U.S. trademark attorney was the U.S. trademark attorney was identified as the point of counsel, but the actual foreign filing company was signing the inventors' names, was again filing through this U.S. counsel, is creating a lot of issues for us. And we've also seen instances, primarily in India, we've seen one in Pakistan, and we've seen a few in China. And one of the reasons we adopted this domicile rule was because of the tremendous influx of fraudulent filings we had been receiving from a lot of it was coming from China and from some other countries as well, where the trademarks were just manufactured. And so this is why we employed this domicile rule in the first place. And we're still seeing some of that behavior, but it has helped to mitigate some of those fraudulent filings. But we're seeing a lot of different types of trademark scams as well. We just saw one a couple weeks ago where They actually signed the trademark commissioner's name, used USPTO letterhead, and tried to assert that they needed to file these extra documents with these extra fees in order to maintain their registration. So we're seeing a lot of fraud before the office, and so a lot of it is because of this this domicile rule and people trying to circumvent it through you know, through inappropriate means.
Glad to know that. I'll just give a brief in-house perspective to it. What for unauthorized practice of law, in addition to your professional requirement to practice, we have already seen, we have seen a couple of paralegals working who is responding to USPTO calls and making necessary changes on the fly. So that one thing which we as an organization have strictly stated that whomsoever is receiving a call has to delegate to an authorized personnel to practice. So we face similar situation where one paralegal has agreed to make a couple of changes in trademark application, and of course that's one form of unauthorized practice of law from our perspective. So we have seen those cases in the past. So probably something from unauthorized practice of law from an in-house perspective, like what we are seeing on a day-to-day basis as well. Yeah. So probably in the interest of time, we have like few broader topics which we all are aware, and by way of definition is neglect, dishonesty, fraud, misrepresentation. So if anyone, Vasundhara, if you guys want to close that with any other topic, and John, probably you can, we can take questions after that.
All right. Thank you, Saurabh. So we've talked about ethics, and we talked about, there are many scenarios where an attorney faces clients who've been accused of, many specific misrepresentations of fraud, for that matter. So as an attorney, you definitely have to be, you have to do your own due diligence before you take up these matters. Your due diligence as a lawyer, not only it's for the best, the best practice, but also for the sake of not taking up a matter which you regret taking up later on. So issues of misrepresentation happen very often in copyright infringement matters. A lot of times there are issues of plagiarism that come out at the later end of it. So that is something that you have to avoid as a lawyer. You have to make sure that the client is relying on something that he has to put forward or she has to put forward in the footnotes. And that's happened a lot of times. I think plagiarism has engulfed the area of copyright. And for that matter, patents has been engulfed by the issue of patent trolls. I think that's extremely important to take forward. I think patent trolls are something that you have to avoid as a lawyer. Other than that, as John was talking about, there's during filing of trademarks, or even during trademark infringement matters, I think it's very important to understand that trade dress has to also be, trade dress is also an important aspect. And infringement of a trademark just for the sake of going to court and putting it forward does not make sense till the time you have substantial evidence to prove that there has been some kind of infringement of your trademark. And lastly, I would say, issues with regard to corporate espionage. I think that's something that happens very often, and that has to be avoided as an intellectual property practitioner. Issues, and lastly, issues with regard to cyber squatting. I think those are the broad scenarios that I look at where a lot of fraud, a lot of misrepresentation happens on a regular manner. And as a lawyer, you definitely have to be very cautious about not taking those clients or those organizations forward in terms of whenever the litigation happens or even during the prosecution stage.
Thanks, Vasudha. John, any example?
I think in the interest of time.
Yeah, sure. Yeah. So probably we'll close this session, and thank you for such a wonderful audience. And probably we'll close this one with one recent judgment from Delhi High Court where a practitioner has submitted a fraud order of an intellectual property board before in a litigation before Delhi High Court, and division bench last year has issued a direction to the Bar Council to issue appropriate directions against the practitioner. So it's very important to keep us aware of these issues. of course, there are n number of things to be like to talk about it, but in the interest of time, we tried to give a flavor from what US PTO perspective, from a practitioner perspective, and what an ethical consideration can be considered from in-house perspective. So hope you all had a wonderful session, and we are open to take questions.
Actually, can I just add one?
Yes,
one other
please,
thing?
John.
I did want to share. We do have something in the U.S. that in most of our states, not in all of them, but it's a requirement for continued legal education. A certain number of hours every year that have to be dedicated to your legal field of focus, and part of that is a requirement for at least 1 hour every year of ethics training. So I know India doesn't have a CLE requirement, but I do think it goes a long way in helping to raise the responsibility of the bar.
Absolutely correct, John. Yeah. Okay. Glad to have such a wonderful audience, and we are happy to take questions if you have any. Yes, please.
Warm wishes to all. I just have one question. Means after post-COVID era, means we are living in a nation where research and development is not as much as par with the Western nations. So when it comes to the R&D and the patents filing being filed by the pharma companies, what about that? Means there has to be an ethical line being drawn, then that has to be in the beneficence of the people across the world. Because when it comes to Asia, when it comes to Africa, and such type of patents won't be there, and those patents must be shared by the Western countries. What's your take on that?
I mean, I'll just comment briefly that what it boils down to is access, right? It's not so much ethics; it's really access, and we've had some great examples of promoting that access throughout COVID globally, and at the same time, we have to make sure that while we support access, and there's so many great examples of patient assistance programs where drugs are donated, the U.S. government donating drugs as well, and other governments around the world into the developed countries, and also through voluntary licensing, the transfer of the technology and the know-how at no cost to many of Indian generic companies throughout COVID to help in boosting the supply of these medicines. So this was, again, I think it was out of responsibility in ensuring access to medicines, but at the same time, we have to be very careful that we don't tip the scale and upset the ability to secure protections for these innovations. Otherwise, we will lose the incentive to invent and lose the incentive to create the next solution that the world needs to solve our next big pandemic.
Thank you, John. And probably in the interest of time, we are around for any further questions if you have any. Thank you, everyone, and thank you, organizers, for such a wonderful session.
Thank you so much, everyone. It was an insightful information, and thank you for sharing your experience with us. Okay, everyone, on that note, we will proceed for refreshment break for 30 minutes. So let's have a refreshment break. Thank you all. Hello, everyone. We're going to start our next session. So within 15 minutes, so I request you, everyone, please come and take your chairs. All right. Are we back from the refreshment break? I hope everybody liked it, right? Thank you. So let's start with our second panel discussion. And the topic would be pharmaceutical patents and access to medicine, examining the balance between pharmaceutical patents, innovation, and ensuring affordable access to essential medicines in India and globally. For this session, I would like to welcome on stage the moderator of the panel discussion, Mr. Sarvesh Singh, who is the Managing Director at Marichi Ventures, Dr. Sridhar Prasangi, who's the Head of IMP Legal at Optimus Pharma, Dr. Bijay Kumar Sahu, Senior Regional Manager and Head Associate Editor in Invention Intelligence, NRDC, Dr. Narendra Singh, who is the Secretary General, ISIL, former Ambassador and Additional Secretary, Minister of External Affairs, Dr. Amresh Panda, Head of Technology Transfer Office, KIIT University. Let's have a big round of applause for all of them.
Okay, good afternoon, everybody. Good morning, everybody. And welcome to the interesting panel discussion. It's on patents and how at the same time we can make sure that innovation is happening and then there is accessibility of medicines to all the patients, right? So my name is Sarvesh Singh. I am managing director with Marichi Ventures. I'll be moderating this panel discussion, which will be for next 45 minutes. So I'll be engaging my fellow panelists for first 30 to 35 minutes, and then we'll open up to audience to ask any questions which you may have, and then we will sort of wrap up. So I will introduce myself and then I will pass it on to my fellow panelists to introduce themselves. So I have been in the industry for last 20 years. I started my career with TCS, worked with them for close to 10 years in India, US, and Europe. Then I moved to an Irish company called Icon Clinical Research, worked with them for another 8 to 9 years. And 3 years back, I moved to Novartis as global head of strategy and operations. In December, I started my own company with name Marichi Ventures, which is more into advisory and consulting. So with this, I'll pass it on to Narendraji to introduce him.
Thank you. My name is Narendra Singh. I am currently the Secretary General of the Indian Society of International Law. And after doing my LLM, I started my career at the Indian Society of International Law as an assistant professor. I then moved to the Legal and Treaties Division of the Ministry of External Affairs, where I spent the next 30 years, and I retired as the head of the division and additional secretary. I was also a member of the International Law Commission at the United Nations for 2 terms, that is from 2006 to 2015. And I also had the privilege of serving as chairman of the commission. In between, I have been, after retirement, I have served as a professor, and currently I am now with the Indian Society of International Law. Thank you.
Hello, myself Sridhar Prasangi. I'm working as an IP head of Optimus Pharma Group of companies. I hold PhD and I was a registered patent agent and LLB degree also. I'm looking in here the portfolio and patent litigations and with respect of legal cases of our company. Thank you.
Hi, hello, hi, good morning. I am Dr. Amrish Panda. Right now I am heading a regional technical transfer office set up at KT University, and it is the initiation of DPT, Government of India. And before to this, I was associated in pharma industry like Sun Pharma and Alchem. I am taking care of the intellectual property and portfolio management and taking care of litigation, then filing of NDA, then patent, everything I am taking care of that. After 15 years, I just shifted the job from IP portfolio to technical transfer aspect. Yeah.
Thank you. Binayji.
Good morning, all. Jai Sri Ram. It is my great privilege and opportunity to be part of this program. I am Dr. B.K. Sahu. I am heading NRDC Intellectual Property and Technology Innovation Support Center at Visakhapatnam. And NRDC is a Ministry of Science and Technology, the primary objective of technology transfer and also IP management in the country. And also I look after WIPO Technology Innovation Support Center. And the basic objective is connecting the dots, taking technology from lab to the land with all kind of value addition, IP protection, management. That's our role, mission, mandate. I'm honored and privileged that I am part of this ecosystem in leveraging the innovation for global sustainability. Thank you.
Thank you so much. So we'll kick off the discussion. How many of you have some background that how much time it takes to get a medicine in the market and how much money is spent? Please raise your hand if you have some background. So I can see only one person knowing it. So for those of you who are not familiar with the field, it takes around 10 years and companies spend around $1 to $2 billion just to get one medicine in the market. They try with more than 10,000 different molecules, and if they are lucky, then one of them becomes successful. So you can look at the failure rate. So 9,999 molecules they fail and only one becomes successful and comes to the market. So today's panel discussion is more on the patents, because if patents are not there, then it will become very difficult for pharmaceutical companies to survive, looking at the failure rate which I just mentioned and the time and money it takes. But on the other hand, if the prices are not lower, then it becomes very challenging for those medicines to be available, especially to people who cannot afford it. So for Western world, it's fine because most of them are covered by insurance. And even if medicines are costlier, they can afford it. But it becomes very challenging for developing countries like India and others, no? So I'd like to hear views from Sridharji that how this patent actually helps in fostering innovation in the global pharmaceutical companies.
So, in pharmaceutical patents, which is in a very plays a crucial role to the innovators to protect their invention. See, for the reason of spending of so much money to get the novel drugs and new medical technology, obviously by the patent they can get the 20 years of term to protect their invention. And the countries like in US and Europe, they are given a regulatory exclusivity also without of this patent. See, they can with patent along with it, they got the regulatory exclusivity. In US, almost 5 years. Plus, they will get another 2.5 years of the further stay that is in favor of innovator. Within the case of Europe also, they're getting a patent as well as the regulatory exclusivity of 10 years. So because they spent so much money on these medicines, so these are the patent production as well as the regulatory exclusivity given by the inventors. Given to the inventors, sorry.
No, thank you so much, Sridharji. Amreshji, can you give us some more details on the regulations which are there in US, Australia, India, and how they sort of help to balance between patents and the affordability of medicine?
Yeah. This is nothing but a balancing act. As you rightly mentioned, all the innovator company, they have put a lot of money to get a product into the market. It's a really, in pharma product. You have to do all the preclinical, clinical, you have to pass phase 1, phase 2, phase 3, everything. You have to. Then after that, the respective regulatory agency, like in US FDA, Australia, TGA, in India, CDA, CO, they will give you the approval. Okay. For that affordable medicine, there are two hurdles. If you are thinking for that for the society, one is regulatory hurdles and second one is IP. In case of IP, let's say you have a patent, so you are blocking the generic company. I can say the other company who try to launch the product into the market for 20 years. In spite of that, you have a chance to non-infringing to that patent, in legal aspect. But you cannot, very less chances to non-infringing the product patent. You cannot bypass the molecule. You have to wait till expiry of the, product patent. That's why TRIPS agreement. I hope you all know about the TRIPS agreement, which is basically give the protection to other generic company. It's a protection to the society, I can say. In that TRIPS agreement, until 2006, all the 2005, all the developed country, you cannot have a product patent. And as I know, it's very easy to, not so easy, you can, 80% chances, you can bypass, you can non-infringing the formulation patent and other patent, let's say polymer patent, you can do. There is a good chances you can launch a product in the market. But still for least developed country, as per the TRIPS agreement, till 2036, they don't, the country, they don't give you the product patent, for the least developed country, as per the TRIPS agreement. This is the part one. The part two is the regulatory protection. In US, as Siddha rightly mentioned, there is a 5-year exclusivity protection for NCE, new chemical entity. But if you have a orphan drug exclusivity, it's for 7 years. And for antibiotic, it's a 10-year protection. Though you have so many things to bypass the patent, but you can't go and launch your product. For US, there is standard bar for 7.5 years. You cannot launch your product into the market like 5 years regulatory protection, 2.5 years, it is called litigation protection, I can say. Because this is just stay, statutory stay by the court. It's all the things driven in US by Hatch-Waxman Act 1984. As per that act, all the things exclusivity and litigation part is controlling. In Europe, it's 8+2. In 10 years, there is a protection of 10 years from the regulatory agency. You can't go to the market. Till 8 years, even if you can't file the generic application in the regulatory agency. And next 2 years, you cannot market your product. And also for pediatric, you can have 6-year protection, 6-month protection, put that additional to 8+2 or 5 years in US. But luckily in India, we don't have any regulatory blockage. There is 0 as of now. Okay. It's good for us. But in US, one more thing is there. This is called patent term extension, PTE and PTA. PT means patent term extension. It's coming from regulatory extension. If your product, if a Pfizer company, Novartis company, they all are big bullies in, it's called as, innovator company. If they don't enjoy their protection in the market for 14 years, at least, then they go and file a PTE. If there is a delay from the, USPTO, they can adjust, there is a calculation, they can get the additional period as well. And if there is a delay from US FDA, they can go file the PTA as per section 154/35 USC. Then you can get maximum period of 5 years extension. We can see many product patent in US, they have an extension of 5 years. Then you can say the patent protection can increase from 20 years to 25 years in US. But India, there is nothing like that. In a summarize, in Canada, Australia, all they have a 5-year extension to the patent, to their life. In Europe, it is called SPC, Secondary Protection Certificate. This is called SPC. In India, as you all know, there is a National Pharmaceutical Pricing Authority. I hope you have idea about that. NPPA. In 1907, they have formed that. Under the Essential Commodity Act, Drugs and Cosmetic Act and Essential Commodity Act 1955, there is a NPPA. They have a list, national list of essential medicine. And as of now in India, there are 384 medicine comes under that. Government is controlling everything about the price and everything. And per year, you can increase the MRP by 10 to 12%, not much to that. So this is the Indian government. They are giving the protection to our society. And in patent aspect, as per the Indian Patent Act, there is section 84, compulsory licensing. All the legal practitioners can know about that section. Under that section, if some drug is not available to the in amount to the society, if the pricing is too high, then some pharma company can go and file section 84, compulsory licensing. But null and void. The patent protection going to be null and void. You can launch the product in the market. Some Glivec, that imatinib mesylate, this is a very good example by Supreme Court of India. So Natco, Cipla, they launch that product into the market, bypass the patent protection. There is no need to wait till expiry of the patent. Okay, so these are so many aspects, if the balancing act, in India, throughout the world, to give affordable medicine to the, society. Okay, thank you.
So far we heard from the speakers that first of all, this R&D and getting medicines in the market is very time consuming. It takes like 10 years. Companies spend $1 to $2 billion. He gave several examples, especially in the Western countries, that how government is helping to protect and make sure that the companies who are innovators, they have exclusivity to sell that particular drug in the market so that they can recover their costs and also can build some corpus for future R&D. So now let's hear from Narendraji that little bit about the history, So if you can tell us something about patenting history, and maybe if you can share some light on Paris Convention, because I know you were involved into those discussions from the government side.
Well, thank you. I think the Paris Convention had generated a lot of debate in India, especially the issue of whether it was in conflict with our Patents Act of 1970. And the major issue was that the Indian Act did not allow the pharmaceutical products to be patented. What it did allow was the process of manufacture to be patented. And while there were two camps, both for and against India joining the convention, the big debate was that this would be in conflict with our Indian Patent Act. And this issue came to be considered in the Ministry of External Affairs, in the Legal and Treaties Division, where I happened to be at that time. And I had studied this matter. The ministry gave its view that the Paris Convention does not require us to give product patents for pharmaceutical products. What the Paris Convention did require was non-discrimination. That is, a foreign investor or a foreign company could apply for a patent if an Indian citizen or an Indian company could also apply for that patent. Any patent which was not available to an Indian investor or Indian company would also not be available to a foreign company. So if Indian companies were not allowed to apply for the product patents in pharmaceuticals, then foreign companies also would not be allowed to participate. So our opinion was clear that becoming a party to the Paris Convention would not require us to give or to grant product patents in respect of pharmaceuticals. Another issue was that of compulsory licensing. Whether the provisions of the Indian Act on compulsory licensing were compatible with the Paris Convention, because both mention compulsory licenses. And here again, the view of the legal division was that the grounds on which compulsory licensing can be given are essentially similar. Although there are differences in language, but essentially, if a product is not being worked, the expectations of the public are not being met, and the products are not available at a reasonable price, then these are the factors to be taken into account for grant of a compulsory license. Now, one difference was as to the period after which a compulsory license can be granted. Here, there was a slight difference in the calculation of the period. According to the Paris Convention, a compulsory license could be considered 3 years after the grant of the patent. Under the Indian law, a compulsory license could be given 4 years after the application for the patent had been filed. So here, depending on the time taken for grant of a patent, we said there could be a minor conflict, but this was not a matter of great public policy, and our law could be amended to take care of this issue. So the Ministry of External Affairs had recommended that there is no bar to our becoming a party to this convention, to the Paris Convention at that time. And it was finally on that basis then that India did join the convention. The Law Ministry was not in favor at that time. But then the Attorney General ruled in favor of the opinion given by the Ministry of External Affairs. Because this is the practice in Government of India. The Law Ministry and the Legal Division of the Ministry of External Affairs, if they disagree on something, on a legal issue, then the Attorney General is asked to decide between the two. And he chose the opinion given by the Ministry of External Affairs, in which I was myself personally involved at that time. So this is how India joined the convention. Later, of course, as we have heard, when India joined TRIPS, then India had to also agree to grant the product patents for pharmaceuticals. Something I think now, we have heard about the costs which are involved in bringing a new drug to market. As we are told, research involves a number of different options being explored by companies, and not all of those the options or those streams of research would result in a successful drug. So there are high costs involved in bringing drugs to market and then ensuring their availability to the public. So this does justify the patent holder having exclusive marketing rights. But of course, if the patent holder is too greedy or whatever you can say, and if the products are not being made available at reasonable prices, then there is a ground for considering of a compulsory license to be given. So here there's an attempt to balance the interests of the investor to allow him to recover the high costs which are involved in developing the new medicines. But here again, as soon as a product is patented, the investor cannot immediately take it to market because there are other regulatory approvals, as we have heard. The federal drug agencies and other agencies have to give their approvals. Human testing has to be approved, and only then the product can be brought to market. So even after grant of a patent, there is a time lag, and part of the patent's life is taken up in this process. And so the inventor must have a reasonable chance of recovering the investment in that drug. Thank you.
Okay, thanks for sharing your views. So far in the panel, we got to know from the panelists on the high cost involved in clinical research and development, the current trends of patenting across different countries, and then a little bit about the history. So now let's switch gears and move on to the commercialization part, because at end of day, if we have an IP or if we have any product, till the time we're not able to commercialize it into a viable business, then that's not of much use. So moving on to Binezi, if you can basically tell us that what are the issues of IP commercialization in pharma and biotechnology sector?
Thank you. And topic is quite relevant to discuss and deliberate, because there is a changing paradigm of ecosystem of innovation and policy practice in the country, from national IPR policy, national innovation startup policy, now the policy of opportunity of mission towards startup and stand-up India. So in this growing opportunity, we have seen the challenges. The challenges is pandemic, but that challenges created a lot of opportunity, how startup came out with new invention, interesting testing and treating of COVID-19. And we had the opportunity to be part of that journey in commercializing some of the technology for the humanity. So coming to intellectual property right, affordability, accessibility, adaptability, because this topic is quite close to me because I did my MPhil on this intellectual property and health biotechnology. So during the Doha Declaration, so history is history already. My respected panelists touch upon the ecosystem and also history of Indian platform, how they became part of the many of the convention in the global arena of the WTO. But one of the very interesting part I wanted to share with you as a IP facilitator and technology transfer professional, if you'll see, yes, intellectual property protection is nothing but creating value. And if we are making into a qualitative or quantitative channelization of that IP into the market, that is nothing but creating value and extracting value. So IP commercialization, particularly this sector, yes, there is a need of technology assessment, validation, and also refining, and particularly the challenges already you have touched upon. But validation is most important. And as far if there is a validation, we must look into the another thing, the benefit sharing, how we are sharing the benefit of innovator to the industry. That is most important, particularly in Indian ecosystem of R&D, particularly in the university ecosystem. Sometimes there is a challenges of benefit sharing because technology came from university or the R&D lab. Is the technology is nothing but the technology at R&D level and in a particular TRL level. So how we are taking the TRL level to the MRL level, that is market readiness level, and taking that market readiness level to the innovation readiness level is most important. In that game, there is a lot of challenges in mitigating the technology value of death and also financial value of death. And particularly this sector, pharma, yes, we are proud that India is the one of the pioneering in the exporting many of the drugs to the humanity and society. But at the same time, we must look into the benefit sharing because invention, innovation come from a institution or institution who are doing a lot of R&D. So that is the one of the bottleneck in channelizing technology transfer from a university to industry, in mitigating the challenge, not only to the challenge of regulatory, the challenge of the policy practice and institutional practice, and ethics and practice is also most important in the Indian ecosystem. So particularly the issues of TRIPS plus is also we must have to redefine, particularly in this part, but I don't want to discuss on that part. Since you asked me about technology transfer challenge is nothing but the challenge of technology readiness level, market readiness level, societal readiness level, and also the innovation readiness level. And finally, there must be a freedom to operate, that is the intellectual property readiness level. These are the crucial component when we are talking about technological innovation. That innovation is going to link to the MSME, startup, and industry. These are the bottleneck. Thank you, sir.
Thank you so much, Binayji. So far from the panelists, we got to know about the different challenges, including IP commercialization. And we also realize that there is a need to strike a balance between patent and affordability and accessibility, especially of the essential medicines, right? So let me put the question to Sridharji that what are the key challenges faced by developing countries, especially India, in striking a balance between patents and affordability and accessibility, especially of the essential medicines?
Developing countries like India, they're facing, like, as you said, the challenges will be there. See, with respect of high cost of price of the drugs, as well as there is a limited budget, and there is no generic competition of the innovative drugs. So there should be a balance between the both factors, like in a pharmaceutical patent as well as the human saving drugs. So my point of view for this thing, actually, that innovator companies must go ahead with like in patent pooling, or else they can like providing of licensing opportunities to encourage the generic competitors to decrease the price, and they have to tie up with NGOs or else the compulsory license providing, so to decrease the price of the innovative drugs. So it can reach us to the people who needs the medicine.
Right. So, Amresh, in case if you can throw some light and build on what he said, especially if we bring this evergreening into the account, right? So, for example, once patents have expired, most of the pharma companies, they twist little bit and then they apply for another patent and then they get an extension, right? So if you can throw some light of your experience on evergreening,
Yeah.
and what could be the best way to sort of tackle it?
Yeah, thank you. For that, evergreening part, as we are discussing about pharmaceutical verticals, there is a second use patent. Let's say
X drug is acting for a disease A, then it can also be used for the disease B. But luckily in India, as per section 3D, Indian Patent Act, you cannot have a second use patent in India. But it's very much, you have a strongest patent in US, Europe, Australia, you can get a second use patent. It means, you cannot market the product for second use in throughout the globe, but in India, it's very much easily marketed. So all the, pharma company, they know, they are also aware about that part. As for the affordable access of the medicine to the market, most of the company, they are using that section 3D as per Indian Patent Act, because there is no second use. Mostly you can't have a patent on that as if you are filing any Indian Patent Office. For that, there are also a petition filed in High Court and Supreme Court, but based on this section 3D, it's strike down. This is the point one. And second part is that about that affordable medicine, I can say a few data. In globally, India or Indian pharma company, they do solve a better job. 60% of the generic drug throughout the global is supplying from India. That's the strength of the Indian pharma company. In US, if you choose 3 tablets from the market, out of 3, 1 is from mostly in India. And in Europe, out of 4, 1 is from India. So in that way, in Indian context, I can say it's maybe the government policy that helps to the pharma company, or the pharma company is targeting to capture the market generically, to genericize all the product, which can, ultimately help to the, consumers to get the product in lesser price. And in that, additionally, I also say in the context of US, earlier it's a normal practice when you were working in pharma company, in a Sun Pharma, they normally file generic, product NDA. This is called abbreviated new drug application. And litigation going on, maybe in Delaware court, New Jersey court. Then after 3 years and 2.5 years or 2 years, there is a settlement between the plaintiff and the defendant. The settlement is that they will giving some reverse payment to the defendant, and the defendant is not launching their product into the market. And ultimately, the US citizen is not getting the affordable price of drug. But in December 2013, the FTC, Federal Trade Commission of US, they filed a suit against Salve Pharma and Actavis. The product name is Androzel, that there is some antitrust law, anti-competitiveness, as is a natural law to the consumers. On that basis, there is a judgment in December 2013. On that, you cannot ask a reverse payment to a plaintiff if you are not satisfying these 6 cause defined by the Supreme Court of US. And it's very difficult to justify all the 6 causes. Out of 2000 since from 2014 till today, there is not a single reverse payment has been done in US. And ultimately, it helps the consumers to the US citizen. So most of the, I can say in India also, one more thing, mostly US court of system, there is a jurisprudence, and they are pro-innovator, but in India, they are pro-generic. I can share one incident about dapagliflozin. It's a, SGLT2 inhibitor. Most of the diabetic patients, they're using dapagliflozin tablet, okay? In US, there is a product patent still active in US in 2025. But in India, all the pharma company launched their product in 2020 October. There is a court, you can check it from Delhi High Court, there is a judgment. The product patent in India still active in 2023. But based on the, pharma, there is a 2 type of product patent, generic and specific. In India, if you have a generic product patent, it expires earlier to the specific product patent, it is easier to cite this generic product patent against the specific product patent to launch your product. Our jurisprudence is support to that. Indian, jurisprudence in patent law. But in US, it's very difficult. You cannot bypass the product patent. So in US, the generic company still waiting till 2025. But in India, you can get dapagliflozin more than 17 or 16 generic company you can get. And one more good thing is that if a generic company launch the product in the market, the value of the drug will be maybe 50th or 100 times lesser in comparison to the innovator company. That's the power of a genericized of a product. But in medicine, so there are so many tools you have to choose and check how you can proceed to the market to available the product to the consumer in lesser value. And as per the IP commercialization, as Dr. Vijay shared about that, there also one good policy as per the IP commercialization, as he rightly mentioned about the startup company or academia spin-off. Nowadays there are many professors, they are trying to be a entrepreneur. One product, what I have transferred one technology from one professor, one academia to a pharma company. This is nothing but a solution which can easily identify oral cancer. Okay, because it's very difficult to take the cell through YSP, go and confirmation that it is a cancerous cell or not. There are two companies in US and UK, they have that product. And the one, if you are going to the doctor, use the solution. In India right now, this is available. You have to pay more than 18,000 or 20,000. But one professor, that lady has patented, this is called TPO, toluidine blue. They developed, invented a same polymer, little bit different purity, based on purity. That lady has the patent on that, and on that basis, transfer the technology to a pharma company. And as per the estimation, the same product will be available to the consumer, where they right now they are getting per session, you have to pay 17 to 18,000. Now the consumer will have to pay only 2,000 rupees. So this is the strength of IP commercialization. Startup company or academia, they are right now contributing to our society. So there are so many aspects. We have to choose the right pathways in which we have to driven the strategy and reach to the market. Ultimately, the company, the generic company will get the benefit and the society as well.
So Amresh ji brought a very interesting point, right? That there are multiple stakeholders who are involved. So on one hand, it is pharmaceutical companies. Then on other hand, these are research institutions and academia. Then we have government. Then we have patient advocacy groups. A lot of stakeholders are involved. And I think it's very important for all of these stakeholders to play their relevant roles in order to make sure that on one hand, the patents are being maintained. On other hand, the medicines are available at affordable rate, especially the essential medicines in the developing nations like India. So I'd like to ask Narendra ji that how can governments encourage pharmaceutical companies to invest in research and development while also prioritizing affordable access to medicines for their populations? It may be developing countries, it may be developed countries, but maybe you can focus more on the developing countries.
Well, I would just like to recall the mention which was made of the antitrust laws in the US and how India was affected by that. In 1972, we had suffered an epidemic and government of India had to import a large quantity of medicines to deal with that epidemic. And the government approached companies in the US. And what those companies did, there were 8 companies involved. They got together and jacked up the prices several times. So because of the emergency, the government had no choice. They had to pay up and they imported the medicines. But then the government took the matter to the US courts, raised the issue under the antitrust laws, and got judgment in its favor all the way up to the Supreme Court of the United States. They held that all those companies were guilty of forming an illegal cartel, of violating the antitrust laws, and so India's stand was vindicated in that. So this is one way in which governments can fight the unjust practices or illegal practices of the big pharma companies. We also heard the mention about the Indian Patents Act, how it is not every minor change in a product which can give you a new patent. And this matter has even been considered by the Supreme Court of India in the Novartis case. The court held that there must be a definite improvement in the efficacy of that product in terms of treating the conditions for which it was meant. And it is not every minor change in the composition that can give rise to a new patent. So companies do try to extend the life of their patent through this process of evergreening, as it is called. But it is for governments to be vigilant and to make sure that they cannot do it unreasonably.
So, since we are talking about government and their interventions, right, to strike a balance, I would like to ask Binaji that how can IP frameworks be designed or adopted to enhance both innovation and access to essential medicines?
In fact, my previous speaker already touched upon the WHO essential drug list part, and in fact, we have a flexibility of Indian policy practice that has been amended time to time. But certainly, when we are talking about accessibility, affordability, and adaptability, see, I will touch upon one size of shoe cannot fit all. India is a country, it has many challenges, and we have seen that, and we can't compare with other country. So that's why Indian policy or the IP policy in all form is very, very well articulated, and also by seeing the challenges. So we have many essential drug list that has been put in place. And also I will say, I think few years back only, but there was one compulsory licensing. So that means there is a balancing of IPR. Policy has been put in place. National IPR policy has also come out. There is a momentum in IP in all sector, not only this sector. And most important part I wanted to just touch upon is particularly the pharmaceutical discovery, particularly in India, is exciting and also transformative, but there is a conflict exists between the incentive to invent and the right of others to access the medicine. That is one of the biggest challenge. And the issues between the fundamental right to access the essential medicine and right of the inventor and investor are must need to consider. It has been, although there are no as such issues are there in the news, though, but there is a news of piracy and also plagiarism. And also, in fact, we have seen the challenges of bioprospecting, some of the issues related to biodiversity, drug development. That is one of the biggest challenges. NBA is looking into it as far as the benefit sharing is concerned. But how we are going to sensitize on that part, that is most important in India. And effective incentive to innovate in the way many countries have, and certainly India has come out. And we have in academia, I would like to bring your kind information. We have a program of SPRIHA. Every university should have a intellectual property policy to harmonize the innovation and also benefit sharing, because intellectual property right is a legal issue. So there is a legal implication, and also there is a biggest challenge. So mindset momentum has been changes in the growing ecosystem, what we are part of it today. So there is a transformation, there is a policy changes, and we are part of it and also making the difference. But certainly IP commercialization is one of the biggest issue. But since the IPR policy put in place few years back only, so we need to create such kind of momentum, then only we can touch upon more IP commercialization or monetization part. Thank you.
Thank you, Vijayji. So before we conclude and wrap up the session, any questions from the audience? Yeah, please go ahead.
Thank you. Good morning. My name is Bongani, an attorney in South Africa. I think I want to just ask Dr. Amaresh on the Balancing Act. Yes, we're coming from the advent of COVID-19, and I was involved in litigation as a lead attorney where we took government and SAPRA, which is the regulatory authority in our country, for excess of ivermectin as a medical intervention during COVID-19. There was serious resistance. Now, can you just explain more on the ethics when it comes to access on crisis and emergencies, where you have a product that's outlawed, but other jurisdictions, there seems to be efficacy and evidence of efficacy and a reluctance on the regulatory body to roll it out on experimental basis, but we have the crisis just on that balancing act, ethics and perhaps humanities.
Yeah, thank you. Thank you for your question. COVID-19 is something I can say it's a serious issue that time, to handle the situation throughout the globe. As you know, for any pharma product or vaccine, it will mostly on an average, it will take 10 to 12 years to complete, starting from IND, still, preclinical, to complete all the clinical stages, But COVID-19 situation, we have some medicine, at least for preventive purposes, to not to spray in a larger way. On that, COVID-19 cases, as you know, all the pharma companies throughout the globe, they have a revenue generation near about $80 billion. Pfizer and all the, Novartis, all the big pharma company. But they have given to the society, to the world, of a saving of $70 trillion. If there is no COVID vaccine, I know there are many more side effects, that's a medicine, all the agency throughout the globe, they have putting under emergency use of that vaccine. Because you cannot complete a genotoxicity of any product or any vaccine within a year. You have to take 4 years, 5 years to do that. Even if for stability study, as per ICH guideline, you have to take at least 2.5 years. Is there any type of impurities producing during the storage? Let's say you are storing that COVID vaccine for 6 months, 7 months, or 1 year. Is there any impurity generating, which has some genotoxicity? We don't know. We are using all the vaccine for booster dose, till booster dose. But it's a necessity of that society that time. So this is I can say this is out of the law. As we mentioned, there's some section about compulsory licensing. It means if some drug is not, let's say there is a protection for a COVID vaccine, still no bigger pharma company, they have a protection or monopoly on that COVID vaccine, because under the section 84 compulsory licensing, it's not affordable to the society. So any pharma company, they can go and file a CL and get that approval to launch the product to the market by completing the BA/BE study, in pharmaceutical. Because if you are generic, there is no need to do all the complete cycle of, clinical studies. So as for the ethical value, you are right. Safety and efficacy is a high norm of standard for any drug. You have to do all the due diligence before to get approval from the respective regulatory agency throughout the globe. But this is a peculiar situation. We have to cite all the legal part little bit aside, because in toto you have to look, yes, there is a side effect that can impact the human health, but if you are not allowing the drug to launch to the market, the death value, it can be 100 times more. So this is a legal, this is a, I can say, public decision made by the respective government. So you cannot imply all the strict regulation there. Or if I know, our honorable Prime Minister also, Narendra Modi, he also tried throughout the globe in global forum not to give any patent to COVID vaccine, because this should not be patented. Because Novartis, Pfizer, they try to have a granted patent and prevent other companies. They have that monopoly because they have that monopoly based on the, I can say the clinical data. Because if you want to produce a generic of COVID vaccine, you have need some clinical data of that innovator, and they are not providing that time. So you can't make a generic product without getting all the data from the innovator company. So this is the peculiar time there, we face, and as per ethically, we have to silence some standard rules and regulation when situation arises.
Narendra, I think you wanted to add some views.
Well, thank you. I just wanted to add one more situation, that the expiry of a patent over any particular drug may not immediately lead to the availability of that same drug through other companies. Because even if another company wants to market that same drug, they have to go through the process of getting regulatory approvals. They have to get the technology to manufacture the drug and get it approved, and only then. And that means even though they don't have to pay the patent holder any licensing fees, there are costs associated. So every expiry of a patent does not immediately result in greater availability of that particular medicine. And this is particularly relevant in one case which happened a few years ago. There was a drug called Daraprim, which is used in certain infections. And in the USA, there were some patients who needed that drug on a regular basis. But the number of patients who needed the drug or to whom it was being marketed was not so large as to attract other companies to manufacture that drug. And what happened, this company which was manufacturing it was acquired by another company, Turing Pharmaceuticals. And realizing that they had a monopoly on this, they started raising the prices. And within a few months, the monthly dose of that drug went from around $13 to around $750. That is when there was a hue and cry as to what is happening. Most of the persons who were using the drug could not afford it. So the company started saying, we'll have a scheme, we will give you rebates, etc. But this shows that it is not patents alone which affect the availability or the pricing of drugs. It is the market size and the readiness of other companies to invest in that area. The CEO of this company, Martin Schrekel, was finally arrested, but it's not for price raising, because in the US, there's no pricing of drugs. Companies are free to make their own prices, but he was arrested for securities fraud. And he was sentenced for about 7 years in prison.
Okay, so I'm just conscious of time. Panelists will be anyways available during the break, so you guys can ask any questions which you may have. I just want to quickly summarize what all we discussed, especially for benefit of those who are new to the pharmaceutical sector. So we discussed about importance of patents and how they help in terms of innovation, especially for the innovative drug manufacturing companies, and how patents actually result in high prices, and how that has an effect on affordability and accessibility of those medicines by people in, say, lower state of the society. And then we also discussed that how different stakeholders, whether it is pharmaceutical companies or research organizations or patient advocacy groups or governments, how all of them can come together in order to strike a balance between the patents, the innovation which is happening in pharmaceutical companies, and affordability and accessibility of medicines by each and every person in this world. No? So thank you so much, Sridharji, Binayji, Vijayji, Amreshji and Narendraji. Thanks for sharing your views. And thanks everybody in the audience for listening us so patiently. I can see a lot of curiosity on your face. So please feel free to catch up with the panelists. Thank you so much.
Thank you everyone for sharing your view and enlightening us with all your interesting information and facts through this panel. Thank you so much. So, we're calling you. Okay, everyone. So moving on to the third panel session, and we have a topic of IP and technology transfer, discussing the role of intellectual property in technology transfer, licensing agreement, and collaboration between academia, research institutions, and industries. For that, I would like to welcome on stage the moderator of panel discussion, Ramesh Kumar Verma, who's an AGM IPR, Tata Chemical Limited Innovation Center, Vaibhav Khanna, Head of Intellectual Property, Sterlite Technologies Limited. We have Dr. Bijay Kumar Sahu, Senior Regional Manager and Head, IPFC and TISC, Associate, Editor, Invention Intelligence, National Research Development Corporation. And also we have Dr. Amresh Panda, Head Technology Transfer Officer, KIIT, TBI, and KIIT University. Thank you.
Good afternoon, everyone. Good afternoon, everyone. So, welcome to the IP and technology transfer panel, and where we are going to discuss the role of intellectual property in technology transfer, licensing agreement, and collaboration between academia, research institutions, and industries. So, along with me, I have my panel members, Dr. Bijay Kumar Sahu, who has joined virtually, and with me, Dr. Amresh Panda joined. So to begin with, I introduce myself. So my name is Ramesh Verma. So I have around 20 years of experience and started my career with the research in one of the CSR research institute. After that, I moved to the service industries where I worked on a consultancy on IP and technology, and then moved to Tata Chemicals 15 years back. And in Tata Chemicals, I have played several roles, including IP management, collaboration, innovation, and also some regulatory aspects. So I request my Dr. Amresh Panda to introduce himself.
Yeah, already you know the same audience, so no need to repeat about my introduction. As all knows, because I am from pharma background, and more than 17 years, I am taking care of that intellectual property and portfolio management with technology transfer. Earlier, I was sitting in big pharma company. I am hiring technology from academia, and right now I am heading a RTTO, Regional Techno Transfer Office, where I can say selling technology from academia and startup company to bigger organization. So I have seen both the face of a coin. Okay, so this much it's enough. Yeah.
Thank you, Dr. Panda. So I request Dr. Sahu, if you can listen us.
Yes, I am audible. So I think everyone knows already I introduced myself. So better to skip this to manage the time.
Okay. So to begin with this session, so when I saw the topic, to my mind, two songs came to my mind. One thing, Ekla Chalo Re, so it's a very popular Bengali song, which I think written by Mr. Rabindranath Thakur, which says that if nobody listens to you, go alone. And second song comes to my came to me that एक अकेला थक जाएगा साथी हाथ बढ़ाना. So it's a Mr. Sahir Ludhianvi. So when we talk about collaboration and licensing in terms of technology transfer, IP licensing, so these two songs plays very well in the role in this thing, because there are two parties, one going alone, other party also going alone. But there is a need that both has to come together and go together, because one cannot achieve what they want to achieve. So in that, I think collaboration and technology transfer is one of the essential component of the overall, when we talk about innovation, research and development, commercialization, and going forward, we are saying developing our developed country want to be developed country. So this has to play a big role. There's no doubt about that. And in India, we have a lot of universities, a lot of research institutes which are innovating, which are doing cutting edge science discoveries, a lot of research institutes who are developing a lot of new innovative technologies. And we have Indian companies who are keen to not only launch new products and technologies in India, they also go globally. And they do try to work with the academia, they try to work with the research institutes, but still there is a lot of opportunities are there, a lot of gaps are there, a lot of challenges are there, and same time, a lot of good stories are there. So begin with that. So I have my panel members, and I'll request to share their experiences, what goes well, where things can be improved on. So first, for any, so I'll start with Dr. Panda. So if he can share his experience, how it works.
Yeah, thank you. Collaboration between two parties, techno transfer, IP commercialization, nothing but you have transfer some technology from lab to the market. As for my experience, as I mentioned, I played from both the side. The inventor all the time play a role of mother of each and every invention. But when it's come to the buyer, to the industry side, they will act like a mother-in-law. सास जैसे होता है, mother-in-law play they are playing. So we as a technology transfer professional, we have to balancing the situation as a moderator between a mother and mother-in-law. Before to start in detail about the technology transfer process and everything, I would like to say a few things. The world best product, starting from Google search engine to pacemaker, seat belt, your Taxol cancer medicine, then your penicillin antibiotics, everything has been, the invention has made from the university, not from any big company. Still COVID-19 vaccine as well. This is the strength of the academia ecosystem in the world, mostly in Western countries. Because there is a Bayh-Dole Act 1980s in the US. Based on that act, that the process of IP commercialization from academia to the industry is evolved. So what I mentioned in all the technology has been matured till at least I can say field validation or proof of concept in lab. After that, all the big company, they're running to the universities to hire the technology because they have master in the market forecasting, and once they know there is a good technology, they come to you, they hire the technology. In my career, 15 or 16 years in pharma R&D, you can touch out of 10, 6 to 7 pharma product, inventive product have been invented from the lab of a university, not from the pharma company. Because in US or Europe, they have a very good, I can say, solid structure. They are funding from the presidency fund in US for that basic research should be going on in university level. And they are getting huge money from them. And based on the Bayh-Dole Act, the universities can generate revenue from that invention to their university. So the two things will impact a lot in US ecosystem to bring this culture of IP commercialization. For IP commercialization, three things measure a lot. One is your technology valuation. Second one is IP valuation. Third one is market valuation. That as for the technology valuation, this is technology readiness level. There is a scale from 0 to 9. Once you have done that proof of concept in your lab scale, then field validation, pilot scale validation, pivotal scale validation, then you can launch your product to the market. But as for the financial budget available to that academia or to that startup company, they can easily reach to the stage of POC, proof of concept in the lab scale. But after that, how to do the field validation, how to do the pilot validation, it's very difficult to a startup company or to a academia, because the fund what they are getting maybe from government or maybe from some ventures capitals is not sufficient to reach to conduct all such type of validation. In technology transfer or IP commercialization pathways, this is called death valley. You can easily reach to the proof of concept. This is called scale 3. But to reach the pilot validation, it's very difficult. They are facing a lot of, challenges. So that's the technology transfer office, the IP commercialization play a bigger role. If there is a complete IP valuation, if there is a very positive growth on that, if you are doing your IP greening with a good TRL at least 4 or 5, and there is a market forecasting, then it is easy to transfer or to sell your technology or to commercialization of your IP to a bigger company. In India, basically, as you know, after US, India is in the second highest number in startup company registration, startup company as per the data, global data. And more than 100 startup companies unicorn right now, more than 100 companies. That's a very good environment in India and very good support from our union government, also most of the state government as well. But the main difficulty, what I found in my career acting as a technology transfer professional, all the academia or startup companies, basically, let's say I'm giving you an example of in case of they are developing some biologics or some pharma product, they are not acquainted what type of product they should generate. Let's say, as I mentioned, there is a called ICS guideline, stability data, because in pharma sector, stability, safety, and efficacy, three things play a major role. But most of the startup company or academia, they are not that much knowledgeable about that ICS guideline, what type of data they should generate. Though government have good facilities, good regulation, good funding, process to enrich them, to strengthen their ecosystem, still we have to do a lot about the technical aspect. We don't know what are the data we should generate, what are the data we should have in our logbook. Then it will easier to transfer our technology from the smaller company or from the academia to the industry. But in Western country, this is very much they have they have the system, they have robust system, they know what type of data they should generate. And initially they are collaborating with the industry. They are putting some mentors into the ecosystem. What are the data we should produce to impress to a bigger company to sell our technology or to commercialize our IP. So this is the basic, difference between our ecosystem to the Western culture. And in India, when I am just changing my role from industry to this, techno transfer professional, few of my seniors, they, laughing at me, Amresh, what are you doing? Do you think you can transfer a pharma product from academia in India to a MNC? It's completely quite, it's quite impossible because the standard is like that. Still, I accept the challenge, and till today, I have transferred 3 pharma product, to the pharma company because I'm putting all the, effort. What are the data should be generated, and after that, the pharma company will look at to the system. So these are the, few part in the brief I am sharing. So what are the difficulty we are facing, but the strength is there. A startup company, a academia, or a company also. Let's say bigger pharma company like Sun Pharma, Glenmark, and if you can search in India, you are not getting any bigger pharma company. They have a product themselves. That's called innovator company. Let's say Pfizer, Novartis. You are not getting in Indian pharma company. They have also generated good, molecule, but once they reach phase 2, they are selling their technology to bigger company because they don't want to face the challenges throughout the globe. So because we don't have that much of courage, we and the Indian people, normally Western people call us, our country is a service-based country, not a knowledge-based country. We are not generated revenue from our knowledge. We are generate our revenue from services. So we have to change the tag. Best, what will help us? This IP commercialization. As of now, India in global IP index in 42 and innovation index, it's in 40 states. Out of 55 countries who are contributing good in World Economic Forum, India still in 42. You can think. But in GDP, we are in 5. In GDP revenue and everything, we are the richest 5 country. But in IP, we are sitting at 42 out of 55. Then we all have to do a lot to change this tag because we should have, because above to us, Singapore, very small country. Even Malta is a very small country. In IP index, that country is higher to us. Can you imagine? We have this much of brain we have in India, still we are sitting in number 42. So there are so many limitations and everything. We have to do a lot to change the ecosystem.
Touched upon a very interesting topic, that licensing of a IP and licensing of a technology, because when you say it means there is a difference. So a lot of time when people wants to license or collaborate with somebody, they talk about they have a technology. Actually they have a technology or not, sometimes it's very confusing thing. Sometimes they have only IP, sometimes they have only technology and IP something different. So I would request Dr. Vijay to talk about his experience, what he is like to share on this topic, that licensing of the IP and technology, and what he sees as a challenge that what people initially face with when they go about it.
Thank you, Mr. Burma. And when we talked about intellectual property and technology transfer issue, we must not forget the technology and also process as management of intellectual property. So one aspect in the Indian context, I will again repeat, one size of shoe cannot fit all. Indian has its own problem and we have many challenges. And in that challenges, we are mitigating also. And that's the beauty of India. So, so far as the policy practice, we have enhanced and compliance all the norm. We have a IP policies, and that has been derived from universities. UGC advise all the academic institution, university to have a IPR policy, because that is the safeguard they can create at institutional innovation at a university level. Second is Government of India has also enhanced the technology transfer organization in every, I mean, as Dr. Panda is also from one of the university looking after technology transfer. So university is in the process of setting up in technology transfer office, and some of the university are doing great in that part, in collaborating, co-creating and celebrating. Third most important issue, you must understand the human capital at the service of technology transfer. What kind of human capital we are utilizing for technology transfer? That is most important. Because if you can keep a people or official or the executive in your TTO, but who do not have some kind of specialization in mitigating the challenge, because we are not only dealing legal right as far as IPR is concerned, we are managing one asset, and that is an intangible asset. And process of taking technology lab to the market, mind to the market, technology at bedside to the bedside. What are the learning mechanism? How to navigate to the market? That is most important. जो दिखता है वो बिकता है. But at the same time, we must to be vocal for local, because our MSME may not be the MSME of the other countries. Our MSME has own problem, own challenges, and also we have to mitigate accordingly at the local demand. And what are the agreement process we are doing, how we are managing, mitigating the technology licensing agreement as a professional in creating value and extracting value and also sharing the benefit. And last most important issue is last two most important issue is the benefit sharing and also management of academic asset. This is I am talking about a university perspective, since we have I think more than 900 university in the country. More than 11,000 engineering college. We have a Atal Incubation Center, Technology Business Incubation Center. I think we have created every institution you go today. We have a Atal ARIA ranking, Atal ranking for institutional innovation achievement, and many of the institutions are doing their best in creating IP. But how they are managing that IP, that is most important, and that is the biggest challenge. And that government of India has also understand. So national IPR policy came, and also one of the biggest objective is IP commercialization. For that, WIPO has been playing an important role, and I myself look after one WIPO Technology Innovation Support Center. How we are channelizing Indian technology for global sustainability, that is most important. And for that, how we are managing it, scouting it, connecting it, and also documenting that technology for global sustainability, because we are part of the WIPO Green in facilitating Indian technology for global sustainability. And another point I wanted to apprise you all, as a technology transfer, national technology transfer organization, how we are taking Indian technology to the global world. And that I will give one of the best case study. India NRDC played a very important role in the past in taking Indian technology, agriculture technology, in some of the country of Ghana and Mozambique and also Ivory Coast. We took the plant, we took Indian startup to showcase their product, and also we availed to this country people in adopting such technology. And today we became ornament in creating a opportunity of livelihood, because I'll give one of the very interesting example of Ghana. Ghana import 90%, Ghana was importing tomato from other country. But India helped in that growing of tomato varieties, Indian varieties of the tomato in Ghana. That NRDC played a very important role, taking Indian technology, Indian people, Indian manpower, and that handhold to the people of that region in demonstration, development, validation, handholding, and finally, we have given the route and they are flying now. So that is the one of the opportunity India has been created in the global ecosystem of innovation. But certainly the issues of IP and technology transfer is nothing but the issues of managing Saraswati and Lakshmi. Although Dr. Panda touched upon mother and mother-in-law, but I will not talk on that point. But Saraswati and Lakshmi is most important. Idea is there. We have to leverage that idea. We have to validate that idea. We have to protect that idea. We have to transfer and monetize that idea in the both qualitative and quantitatively. That is the need of the hour in a ecosystem where we are part of it, to strengthen the regional innovation ecosystem and taking into a national innovation ecosystem, as well as taking that Indian innovation ecosystem to internationalizing innovation ecosystem for global sustainability. And these are some of my point, and that is need of the hour. And already we have put in place such kind of policy framework in the country. But it is the responsibility of respective university and institutional leadership, how they are driving in connecting the dots. Thank you all. God bless you. Jai Hind.
So thank you, Dr. Vijay. And you mentioned a lot of words. So one thing you talked about WIPO Green, just for the knowledge of the audience. WIPO has started an initiative where they list down all the green technologies, whatever is available globally. So any company or any individual who has developed a technology, which they feel that it's a green technology and going to work on sustainable, they can list on the WIPO website, and it's WIPO facilitate the collaboration with the potential licensor who could be. So that's the initiative of the WIPO Green. And you talked, Dr. Bijay, about Saraswati and Lakshmi. So I'll talk about a little more on that, what you mean to say and that. So when we say IP, so it's a IP means it's an invention. So in the corporate, so when you say that I have an invention, so and somebody says I have an innovation, and somebody else says technology. So all these three words have a different meaning for companies, because your IP protection gives IP gives a protection for invention. So when you say invention, so it could be a part of it could be a big invention, it could be a part of a big, small part of the big invention. So that's what IP is all about. But when you say innovation, so companies look for innovation for a particular challenge. When they have something challenge, so they don't just say look for one invention, they try to find out somebody who provide a solution. So it could be, they look for innovation. So for them, innovation means something goes to the market, gets used in the factory or in the process, and gets commercialized. So that's what general industries mean by the innovation. And when you say technology, so technology, I think from the corporate perspective, it becomes a little much broader than it's just invention and innovation. So it's like all the other component which is required to go to to set up the factory and go to the market. So essential component is what it's called about. It's called the technology. So a lot of time when academia and research institutes, they do their inventions or innovations, and they try to collaborate with the companies. The first thing comes the disclosure part, what they disclose, what they should disclose, what they shouldn't disclose. So a lot of time that challenge comes whether there should be some mechanism, what they should disclose, what shouldn't be. So I'll start with Dr. Panda to share his thought, how do they go about it?
Yeah. As per the process of technology transfer, it has been started, information, your invention, you have to disclose to the buyer, okay? Because the disclosure part, if you have already a patent in process or you have a granted patent, it's situation based on that. If you have already granted patent, then the amount of know-how you are disclosing to the industry or to the buyer, the risk is little bit less. But if your IP application still in process of examination, and you are not damn sure that the chances of have a granting of that application is 100%, then you have to play a role. Yeah, your technology transfer office or a technology transfer professional has to play a major role, that the know-how should be, because you have to furnish all the data after signing the NDA, because the NDA non-disclosure agreement also is a very important role play during a technology, licensing agreement signing. Before to this, you have an NDA with the, I can say the licensee. During that NDA, this is a legal document. You have to mention each of every point. In that part, there is a disclosure of information section is there. And what are the period of that information the licensee should keep in his ecosystem, and who are the person can reach to the information. So as per our standard of writing, that should be limited to their employee. It should not go outside any third party as per the NDA. This is first thing, because once the information is out of open from their ecosystem to other third party, let's say some legal entity or somebody else, so there is no surety that the data can also be reached to other party as well. And if there is a patent specification in the public forum, because you have to disclose everything in that patent, a person having ordinary skill in the art can produce the product or process into their lab by following the specification. And if all the know-how, all the details you have sharing to any person who is not coming under that CDA or NDA, but that's very problematic to you. Basically, in the context of India, as you know, it's very difficult to go to a court and prove a infringement lawsuit in India. It's very difficult. But in US, yes, you have the upper hand. If you have some good data in your hand, you can prove it. But in India, it's very difficult to take the damages from the, I can say from the infringer. Okay. So we normally practice not as stringent as much. Don't transfer any material in initial stage. If you have something, I can say, let's say you have a product, though you have disclosing few parameters and all the parameters in the patent, still a person cannot reproduce the same product or process into their lab once going through the specification. There are so many. As I am from pharma background, I know mesalamine, metoprolol. You can read all the patent, you can get the know-how, still you are not reproducing the same product, same formulation. You can't do that. Pharma company, you know, in the metoprolol, all the pharma company in India, they are investing huge revenue. You know, this is a very good market and getting the patent has been expired. Still, they are not reproducing the same formulation into their lab. But if you have that type of, you know, peculiarity of your product, you can, you know, disclose as much any data to the against party. But if you know your process is so simple, it can be easily reverse engineerable, and can the product can get all the data by anybody, person having ordinary skill in that art. So be careful when you're drafting your NDA, what you are sharing to them. If you are transferring some material, so the MTA, material transfer agreement also, writing in that context, how to protect it. So each and every legal, we cannot discuss here. So what are the, we have limitation we are putting there, as I mentioned, to whom you are sharing, and who are the person can get access to that document what you are sharing to your, you know, future licensee. So these are the whole aspect we have to take care of that during, you know, transferring of data or disclosing data to the against party.
So, okay. So to adding to that, so in my experience, I have seen a lot of times, so during technology transfer and IP transfer, it's a process little smooth in signing NDA, but a lot of time happens the companies or parties, they approach to a university or research center and they for their specific solutions, and they try to seek that if the other party can help them technically and provide the solution to it. And that time challenge comes that who is going to be the disclosure for this confidential information, whether the party who is disclosing it or the academic institute or the research institute who is going to provide a solution, they are going to disclose. So, and a lot of time, both parties don't agree to it, and a lot of it goes to a lot of discussions and it takes a lot of time. So I would request if Dr. Bijay Kumar have some experience on such challenges and he can share.
Technology transfer is nothing but kabhi tali bhi milega aur kabhi gali bhi milega. So when we are talking about transferring any university technology, and I will caution, sharing and caring is most important and trust is most important. If there is a IP protection, we must have to share the information based on our collaboration. And in that collaboration part, we must look into the liability and redress. And in that liability and redress, we must have to create such kind of mechanism so that there should be a win-win situation. So technology, particularly university technology, yes, you know, university has own challenge and own opportunity. And it being an institution of academics, their technology may not be ready for commercialization. So what are the benefit of opportunity we are taking from industry in doing the technology validation. I'm giving one example of one of the institution where the industry help and handhold for validation of technology because they had a industry academia collaboration for that purpose. So we have to identify the partner, and that a partner is none other than the partner who is existed there. So they have a trust, they have a belief, they have a understanding, they knows very well about the technology because they are the creator. They are, they are, mother of the technology. So because it is a collaborative technology. So, but in that part, the issues of intellectual property protection. Many of the university do not have an awareness, particularly is that every day years you have to pay annuity fees. Who will pay that annuity fees? Further, particularly many universities do not have such kind of funding for payment towards annuity of any patent. So one technology may have a many patents. So who will be the responsibility and how the intellectual property management cell is there or not to mitigate such challenge? So that is one of the challenge we do as a national organization. Not only to that, we also protect the IP, not only patent, we look for a copyright design. And if it is a startup, we also handhold such kind of startup. We bear the cost for the same also. So that freedom to operate, we channelize, manage, and second is the technology validation and also certification. Jo dikhta hai, wo biकता hai. So how you are certifying, because we are in a transparent ecosystem. We can't misguide or misinform to anyone in the knowledge economy because this is a knowledge economy and it is knowledge intensive and knowledge must be acknowledged. So that is most important for an institution like us to safeguard the institution, individual, industry in mitigating all form of challenge when we are licensing any technology. And most important, I must not forget, when we are transferring any technology from a public institution, we must look the objective identification as well as the term of licensing, because we are transferring from a public institution as far as the technology is concerned, that to a industry or startup or MSME, we have to mitigate the government policy so that it should not be a problem against the administrator of that university or institution or the inventor. And lastly, as per the IPR policy of, the policy that has been put in place as a reference copy in our government of India, the IPR policy framework we must adopt to create a benefit sharing, ownership, liability, and also transfer of right. That is most important because we have a larger ecosystem of educational institution in the country. So invention, innovation, as Dr. Panda told, that university is giving many more technology in the recent times. And we have to look and create the opportunity for that in bridging the gap between academia and industry and technology transfer. And we must have to acknowledge it fast, because acknowledgement gives opportunity to a professor or researcher that he is or she is created of that invention that will give the opportunity or supremacy in the field of invention, benefit sharing, recognition, rewards. In fact, NRDC was giving National Innovation Award, Budding Innovation Award from a university who creates such kind of IP and invention, taking into a next level. And that has been there, and that will create an opportunity for them to showcase in the global economy for more collaboration towards sponsored research, collaborating research, granting research, and also contract research, because contract research and these are not there in Indian university and looking for that institutional framework. Thank you for giving this opportunity. So anything else there, certainly I can do my best. Thank you.
So thank you, Dr. Bijay. So Dr. Panda, so I would like to ask a little more specific questions on the same topic. That when you do you have any standard licensing agreement, or you decide on case-to-case basis? And further to in that, if you can cover on that, key, how do you take care on the, suppose you have licensed a IP. So if there is improvement in that IP, who is going to own it? And if your license is what type of license it's a, and is there a, like you say that key, whatever I'm giving it, I am responsible. Tomorrow something goes wrong, somebody says that it's you are infringing somebody else's right. So who owns that, takes the liability part? And is there any other thing you consider that? Because when some other party pays money, he wants a value out of it. If he's paying 10 rupees, he will definitely, he's going to seek that his 10 rupees is going to recover in next 1 year or 2 years.
Yeah.
So how do you ensure that keep all the expectations of the other parties met?
Yeah, as per the licensing drafting or a licensing agreement, it's not at all same. It's based on product to product. As per the classification of licensing agreement, we are targeting maybe exclusive licensing, non-exclusive licensing, or limited licensing. Okay, based on that division, exclusive licensing we will know there is only one licensee. For non-exclusive, there are many more licensing. Okay. And for limited licensing exclusive agreement, the jurisdiction based, let's say you have a patent in India or also you are protecting your invention in US, Europe, then you will choose a partner in India who can sell the product in India only. And that same company has not that much of strength or capturing in the US market, then you can also give that licensing only limited jurisdiction licensing to company A for India, and for company B who have a better or deeper reach to the market, you can give the jurisdiction of the US to company B. But this is called restricted, and also it can be also used based. Let's say same product. Let's say you have a microbiology based light, nowadays is a green light called. You can use somebody, you can give the product for street light, somebody for household. It based on the use limited exclusivity. But based on the targeted customer, who is your customer, how much strength of the customer, let's say I am selling my technology to a bigger company like Tata company, then I should target for exclusive licensing. Let's say there is a company of net scale, then it will be preferred to me to go for a non-exclusive licensing, not for a licensing, because the company cannot give me that much of upfront payment, or also I cannot get that much of revenue generation from royalties. That based on who is the buyer, about your technology, and about your IP protection. The second thing is that as per in future, because we are all the time thinking about patent, and patent. But nowadays the trend has been changes. Let's say patent only give you 20 years of exclusive right, and out of this somebody can infringe. As I earlier mentioned, in India it's very, very difficult to catch the infringer. And also it's okay, you catch them first, then to prove it and to take the damages in the court of law in Indian jurisprudence is very, very difficult. Okay. So nowadays, most of the companies, they are playing like as a trade secret, That's also a very great aspect. If you really think your product comes under trade, you can manage it under trade secret, then you should choose the IP of trade secret, not go to the patenting way. Because patenting means you are disclosing, you have lot more of challenges. And one more thing, as I hopefully most of the people know that, the most number of highest sue made against a person who has invented telephone, Graham Bell. 640, sue has been had filed against that guy in US court of law in Toto. Can you think? Because the invention is a huge, all the bigger company, when that guy tried to licensing the product to one company, the other company, they try to, I can say it's an tactics of pressure. Okay, 640 litigation. But these are also one aspect to that is smaller company, MSME or any academia part of that. So as my, experience, what I'm sharing, it's product to product based. You have to evaluate diligently, okay, where your IP is. If in Indian context, I'm saying, a little bit we are doing good in global context. Still, if you are checking, more than 80 to 90% Indian patent, they don't have any PCT, they don't go to any, other country to protect their invention. Because they are only targeting, yes, I have an Indian patent, that much, okay for me. because they are not, because they don't know how to commerce. This is the role of IP, technology transfer. Because if a company, smaller company or MSC company or a academia, if they don't know how to generate revenue from their IP, so they are not interested to protect their patent in outside India like US, Europe, because getting patent is one thing. After that, you have to pay the maintenance fee till expiry of the patent. For that, you need revenue to pay the maintenance fee. Okay, so these are the aspects about that IP status, IP coverage, then type of product, and who is buying. Okay, who is buying your product? So, and also what is your patent life? If there is a patent life of 4 or 6 years, so then you should choose for a non-exclusive pathway, because nobody is interested to take the exclusive pathways. So these are the factors normally we do consider when you're going for the signing a license agreement during our normal, normal pathways of a course of action.
So thank you, Dr. Panda. So just to add my experience in that, so most of the time, what happens, people try to license their IP and technology. And the success, if you see the success rate, that's not so great in India. But one thing I have experienced in the corporate, that what works well is the, instead of licensing, go in a collaboration mode. So like initially I said, na, एक अकेला थक जाएगा मिलकर हाथ बढ़ाना. So what companies prefer to do that from the initial stage, they try to identify who could be their potential customers from that company perspective. And instead of developing a product and technology and later on offering them as that this is what you buy it, they collaborate initially that, okay, let's do it together. You develop your market, I'll develop my technology, my product. So they build a consensus as that what is the transaction is going to look like, where both parties are win-win. So what other partners get, they get a first access to the new technology, new product, which is not available in the market, and the developer or the other developer gets the customer ready customer, that if his product is successful or technology is successful, he has a ready customer. So that model I have seen in the corporate, it works well, very well. So that's one thing I think can be adopted for other academia and research institute as well. So, and that's I think good model. And the risk of IP is less minimum there, because parties are clear there that what they are expecting from out of this collaboration. So it's not about a license, state license, it's a collaboration, both it's a collaboration thing. So, and Dr. Bijay has been saying about benefit sharing. So benefit sharing, there are two concepts. One is when academia, university or a research institute, they license their technology, some of the amount goes to the professor or scientist. So, but in corporate, I think that's not a mandate in India, but in Germany and some other countries, there is a law that inventors should get paid if their technology gets licensed or commercialized. And another concept of the benefit sharing, which is very legal in India, it's called Biological Diversity Act. So if you are taking a license or collaborating on a technology from an academic or research institute, and tomorrow you are going to commercialize it, and it includes some biological resources, you need to see that if that particular technology requires a benefit sharing payment to the as per Biological Diversity Act. So I think now I'll open the floor for questions. So if anyone has any questions, please, you can ask. Please introduce yourself, then you can ask the question.
Sure. Good afternoon. My name is Renuka. I work at a law firm, Lal and Sethi. It's an IP boutique firm based in Delhi. This is a very interesting discussion. You talked about how in some situations licensing does not work, and in that case, collaboration is probably the way to go. But does that not lead to questions of who will then own the IP that is being created if you are collaborating between two parties?
In collaboration, that's the interesting part. I have seen that parties collaborate with their potential customer mostly. So they know that this is my domain, this is my boundary, and this is what the other party's boundary. And that time they decide that, okay, let's own the IP. In my boundary, I am going to own my IP, and beyond that, you are going to own anything jointly. They prefer not to go jointly. If there's a joint, that time they figure it out, because joint thing sometimes it's sounds very good that I have a joint IP, but for a company like us, joint IP does not always helps us. So that's why in the initial phase itself, they decide that what they are going to own, what if you want to own, you own it, but what I'm going to develop for that, I'll keep it public.
Yeah, for that, there is a term sponsorship agreement. Okay. If you have developed invention from academia or startup or MSME, then you reach to a bigger company. If they have evaluated and they are not that much of damn sure, okay, they should buy the technology from your ecosystem to their, site. So they are agreeing for sponsorship agreement. They are putting some money to that do some much, generate some few more data for that, I can say for pivotal batches. So in that way of line, already you have generated a IP. They are putting the fund for that. On that basis, they have a agreement earlier. Once there is promising data generated out of this further research, they will hire your technology, as per the licensing agreement. Second part is that a collaborative your questions. Let initial stage, if they think your university, let's say Massachusetts Institute of Technology, then Cornell University, they are normally called as a platform technology based university. The university, the industry ecosystem knows that they have very good talent pool, and initially we should collaborate with them. Nowadays in Chennai IITs, most of the industry also, they are doing such type of collaborative research. And in that part, as he rightly mentioned, because if the party is IIT Chennai and one party is, let's say, a bigger MNCs, okay, some institutions, they are normally thinking, of course, yes, they are looking for the generating of revenue. Still, they have little bit soft corner to the socio-economical impact. But as a MNC, they are pure business guy, they are thinking for revenue. In that way, the conflict is coming, okay? So normally what happened that time, mostly the bigger company, they told we are paying you. Normally in US, they are playing in that way, I can say it's a assignee transfer. If I can check in US, the assignee transfer is very common, but not in India. In India, if you are coming to a university and to a professor, if the professor is an applicant of that Indian patent application, the company is wishing to take the assignee. The innovator, you can't send the innovator as per the law, patent law. Innovator will be sent throughout the life of that patent. There, they thought कि नहीं मेरा सब कुछ चला जाएगा भाई. I have lost everything. But it's a very common practice in US. If you are following that pathways, because assignment is the major role. Who is going to sell the technology? And as per their signing agreement, the percentage of revenue come to the innovator. If that will be the pathways between the collaboration, let's say the MNC will take the assignment part, and in initial stage, they have a license agreement. They have an agreement between them. Out of the revenue generation, I will pay 30%. You have 35% or 40% to the innovator. And nowadays in abroad, if you go there, so they have a pattern like that. If you are generating this milestone payment, this is called. If we have generating this much of $1 million, then the percentage is 30% to the innovator. The company will take rest the same. If it is cross, 5 million, then the percentage will be higher little bit, lower little bit. So that will be the right way. But putting assignee to organization, it's very difficult. So you have to, as a company, you have to give that much of lucrative amount of percentage to the innovator. But then hopefully you have a better chances there.
I'm Advocate Sanjay Chowre. I have a curiosity about liability in technology transfer of various stakeholders. Could you throw some lights on that, please?
So liability is one of the mainly in technology transfer, there are two kind of liabilities generally arises. One thing is the performance of the technology, and the other is the third-party IP. So mostly companies go for FTO kind of study. So FTO called is freedom to operate, where they check the first as a it's a due diligence study which gives you that whether you are going to infringe somebody's patent or not, and that based on that parties decide that who is, because if it is a academia or research institute, generally they don't take any liability beyond what you are paying them. So because they say we cannot pay you more than what you have paid to us. That's the maximum they can give you. And on performance side, so as a corporate, we generally prefer instead of going directly. So any the practical aspect, we prefer to go on milestone based. So instead of going directly and take a license directly, first you let them like Dr. Sahu mentioned about technology readiness level. So check that their technology readiness level, put the milestones that you ensure that your payment is linked to the milestones. Once they complete the milestone, then you make the payment and give your whatever payment royalty and whatever it based on that milestone. So that's how they try to minimize it. So there's no standard answer to it. So it's based on the mutual.
Yeah, add to that, as you rightly mentioned, FTO clearance, freedom to operate, this is the backbone of any licensing agreement. Second, the IP valuation, that's also very important, because though you have a granted patent, it doesn't mean nobody can invalidate your patent. It's a normal practice in US. For all the generic company, they are normally try to invalidate the granted patent, okay, to have a settlement with the plaintiff. The third part is the milestone payment, as you mentioned, okay, because never ever you draft a license agreement like that's a one-time payment. No. During license agreement, let's say the upfront payment and royalty, there are two types of payment, okay. As per our technology transfer ecosystem, let's say the valuation is X amount. Out of the X amount, 20 to 30% should be covered during the upfront payment. And rest 70 to 80% you should put in the royalty base. Because royalty, once the product is in the market, then there will be no loss to the company, also no loss to the innovator. During also that 20 to 30% of the upfront payment, you should go for the milestone payment. During signing 10 to 20% or something like that. Okay. After that, because the transfer of technology from the site of innovator to the site of your company, it's a huge. In pharma, I know if you have a product past the pilot scale study, there are 50% failure in pivotal studies. Its variability is there. You are preparing 100 product, you can pass the test. Once you go for a larger manufacturing 1 lakh product, there is much more variation is there. So you should based on the milestone payment in 3 or 4 milestone payment within 1 or 2 years. Okay, and the milestone payment also like a upward hills, not downward. The initial payment will be a little bit lower, 10 to 20% is increasing. But this is the way because you cannot put any liability use to the innovator. If you are putting the liability clause completely on the innovator, if that is a startup company or a professor, then I can say it's against the natural justice, because they can't bear. They are inventing something. They have given their report. You as a MNC, you have that much of strength, manpower. You can go for the freedom to operate searches. You can go for the, ask for the milestone payment. You can know the market, available market forecasting, everything and you have a talent pool. You have a talent pool who can evaluate the technology aspect as well. So this is the normally, we are playing in that way. So because as a technology transfer professional, normally we do play both. We have to protect the interest for both the parties. And because in other words, most of the bigger company, they are taking the technology. After that, they are not caring the innovator, because they know that not, because you all are lawyers, a innovator can't pay you that much. The professor can't pay you that much to fight a court case in the court of law. But the company has a, man of 20 or 30 big lawyers. They will bully the innovator, in the court of law. But this is also a risk to the innovator side. So we as a mediator, I can say, facilitator of transfer the technology from that ecosystem to the bigger ecosystem. We have to take care of both the parties' interest. Yeah.
Hello, I am Ananya Agarwal from Ace Legal. Sir, you mentioned that the trend nowadays is to go more towards trade secrets than patents. What I wanted to know is what are some considerations as, say, an inventor or owner of such technology to go towards the route of trade secret and not actually go for filing of the patent?
Yeah, it's a very interesting question. In US, the trade secret law is so strong, but not in India. For the trade secret, let's say you are a MSME or you are a startup company. You have some employees are there. They have to, often to their, your know-how. So during giving your life, employment, you have to mention such type of stringent section in your employment letter, appointment letter. Okay, they should not disclose anything to any party, or if they are joining to next company, the same person should not be party of that such type of invention. That will be comes under conflict of interest. Okay, you have to putting such type of clause during giving the appointment letter first of all. Second, you have to choose. Should I go in patent pathways as I mentioned? Your know-how, how complex is it? It depends. If it is a very simple process, you should not go for the trade secret. If one day you are launch your product to the market, some same player who are playing in your same, code, they will take your product, reverse engineering your product, they can get the know-how. So your technical acumen should like that. Is it a simple or is it complex? If it is a complex, then go and choose the trade secret. Though your employee not disclosing the same to the market, but somebody, other party, they can generate the knowledge, okay, from the product. Third party is that if your product is a combination of A, B, and C, okay, let's say you have a component A producing by X employee, then B, and you should not have a contact between A and B. You can also place that such type of equation as well. I can say it's contributory innovation. Okay, so you can strategize accordingly. It's not like everything I should copy. Trade secret is the best way. You have nothing to, invest money, nothing to pay any IP lawyer, nothing to pay maintenance fee, but the risk is higher. So this is a balancing between what's your technology or the way, in what way you should move ahead. That's why I'm giving you an example of bacteria. As for the section, you can have a patent on microorganism. Let's say your invention is based on that consortium of bacteria. Okay, then as per the law, you have deposit all the things to the NBA, National Biodiversity Authority. As per the Patent Act, never ever you can get each and every detail of the bacteria in the patent specification. You can have putting the code, which is given by the NBA. So in that case, you should go for trade secret. But nobody can get each and every information about that bacteria, how to prepare, what are the all details of that bacteria from patent. The only code will be mentioned in that, and all the information will be with NBA, which is highly confidential. In that case, you with a blind eye, you should go for the trade secret. So these are the in which field your product is actually. Okay, yeah. Sorry, the person is waiting for that actually. Yeah.
My name is Ahmed. I'm practicing law in Egypt and Saudi and Emirates and Jordan. I'm currently leading the legal team of one of the health tech companies in the Middle East. So I have a couple of questions. I wanted to follow up on a couple of discussions here. So regarding the protection of patent and trade secrets, I believe the patent is more weighted than the trade secrets, because even if you mention something in the employment agreement regarding the trade secrets, practically you won't be able to protect your rights. I've seen like tens or hundreds of cases where employees jump from a company to another and use the X company's data, even to establish a new company competing with the X employer. In Egypt, for example, I've been working on a case. A company that was actually developing a software for booking doctors. So they had a platform or a list of doctors with this list of specialities and addresses and the fees paid. And one of the employees that we used to work for this company started his own business and took the list of doctors. And it's a pure competing business. And the ex-employer sued him, and his defense was that this list or the development the company has done to the list of doctors, you can find it on Google with the name of the doctor, the address, and so on. And although the Egyptian intellectual property law says that any sorting or grouping or listing of specific data shall be deemed as a patent. But on ground, as I said, on ground, the burden of proof is impossible. Responding to your question, even regarding the NDAs or anything related to this, it's very hard to prove that this employee stole this specific thing from a place to another place. So I believe keeping it as a patent is way better than dealing with it as a trade secret.
As I mentioned, okay, as per the NBA, or what I given the example right now, this is related to microimage invention. Okay, you can go for the trade secret. Nobody can get the data, not at all, because this is coming under your NBA. So I am not telling you are not using the patent. No, if your product is so complex, as I mentioned in the last part, the mesalamine and metoprolol, this is a drug. You have patent. You cannot generate any percent product in your lab. So you have to check what's your product, in which field it is, and it's a simple or complex or not. Because in patent, as Coca-Cola, any company can till yet produce no reverse engineering of Coca-Cola product. Am I right? So how it's protected right now? And also it depends on the jurisdiction. As I mentioned, in India, there is no stringent, hopefully in developed and least developed country as well. But US, they have a very stringent law in trade secret. Because you have to prove in court of law, if there is any infringement of your trade secret. So that depends on the legal jurisprudence of that jurisdiction.
Okay, and about India, for example, the UAE published a new law a couple of weeks ago that if an employee breaches the NDA, a fine may reach like 500,000. Yeah.
I'll just add in what he said. So one strategy doesn't work. So it's like you have a patent and some information you can keep as a know-how, because which you need to decide on case-to-case basis. There's no standard. And as such, trade secret is not a formal protection. It's you need to keep it secret. So you need to take a measure in all those things. And other people are free to do the same thing, create reverse engineer it and everything other than your employees. So only you can bound by your NDA and contract to your employees or somebody or partners to whom you are disclosing. Rest of the world is free to create and develop it same thing. Like in microbe, he said that that's opportunity, but other person can isolate a better bacteria. So that's microbe. So that opportunity is there, like you said. So yeah, it's not. And in India, so for employees, there is a contract act. There's in contract act, there's I think section 27, which says that you cannot have a restrictive employee. You cannot restrict an employee working in the same area. So you cannot formally say that unless you prove it that he has taken data directly from your company and misused it.
I'm Professor Aparna Raman. I am a faculty at my university's National University of Singapore and at IISc. So we have a lot of research centers. My concern, because the universities, the research centers are also basic and applied research. There is a distinction. Number one, only when it's applied in a commercial aspect, but there's a lot of basic prior research to that. My concern is a lot of issues that we've seen is regarding the funding. not just attribution, but also allocation, the percentage, the proportional allocations. Attribution is one thing, but allocation and association is another, because anything in, see, the wheel is never going to be reinvented. What we are going to do is derived and based on certain, for example, AI. A lot of our work uses AI and these emerging technologies where there's a component of AI led and there's a component of human led. So how would you attribute? How do you segregate? How do you allocate this? And the point is that these researchers are being increasingly collaborative in nature. There's no person who's going to do it singly. It is always a, in a group, in a team, in an MOU between institutions, and mostly it comes out of institutes and then the industry. There's a lot of linkages between industry and institute. So how do we, is there any policy effort at all in this country, which I don't see at all, because there's a gap so much, because outside we have a treaty level, we have the international law level, they're harmonized, but here there's absolutely no policy when it comes to R&D, allocation and attribution, especially when it comes to funding. So who is it anyway, and how do you take a long-term view of it? Because these are long-haul projects. They are not a day-to-day. You take a 5-year, 10-year gestation, you take that generational view of institutionalizing it. Thank you.
So thank you. I think what you said, it's a gap, so it's a challenge, and currently there's no solution to it. So let's hope that people like you come in such forums and raise these things, and someone comes with the solution to it. That's what only I can hope. So the last person who is the
Yeah, actually, you rightly mentioned, because you can see from our Indian aspect, the fund we have allocated from our general budget, it's very less. As per your fund allocation matter, but I can say as of now, let's say you are a researcher, you are from academia. Initially, I hope you have an idea. There are so many funds you can get it from government. Initial stage to reach the technology readiness level 3 proof of concept in your lab you can develop. After that, there is a second line of, where you can transfer your technology from readiness level 3 to 6. But it's a highly competitiveness. So let's say recently NRDC given like 1 crore to 2 crores. There are MITs there. Yeah, you have to target that as well. There are, I can say, near about 10, funding type of, I can say, agencies in Government of India. You have to apply for that. And thirdly, venture capitals. Okay. As per the research, if I am putting that, earlier there is an investment of huge in startup company in India, near about 22 million. Right now it's decreased to 7.5 million in 2023. There is a decreasing. But the funding to AI, clouding system, and space research done by some startup or faculties, this is good. But other than to this is very challenging. But getting money from AI or VC. That's the role played by technology transfer activities.
The other challenge is what is AI based and what is human based.
Okay. About that, you can contributing that machine invention. It's a topic right now throughout the world. The machine can be an inventor or not. So we can discuss out of the yeah.
I think let's take the last question and then close the session, and because we are
limited of time. Yeah.
Your lunch and you. So.
Hi, greetings of the day. Tanishka this side. I'm working as a legal counsel in NGO by the name of Save the Children India. So working as a legal counsel, there have been n number of agreements that we encounter. So when I talk about branding, collaboration, white labeling, and different donation agreements, being an innovator or being owner of the IPs, till what extent should we give the usage consent of the IPs to other party in the agreements?
I think there's no standard answer to it. So you need to decide that what is your plan for that. So if suppose you have a technology and you have an innovation on that, what you want to do with that? Whether you want to commercialize to this party only or you want to give it to somebody else. If you have a future plans, then you can restrict it to the party. If not, try to get the maximum value what you can get from the party you have who is ready to take it to the market. That's my suggestion.
Yeah, for that, as I know that a child contributed to IP means patent if there is a patent, current patent, and as per the licensing agreement, you have to put the patent number there. What you are covering? In US context, this is called child continuity. Okay, patent greening. In Indian patent addition or divisional patent. All the time should try no divisional patent should come under the license agreement. Because your divisional patent will be a little bit different, invention. It's not coming under unity of invention. Okay, child continuity you have to put because without parent there is no standard loci of a child continuity. Patent edition. So as per that, we as a techno transfer professional or IP professional, we are taking care of that. That license agreement should only capture that family, not taking anything beyond to that. If I am doing some derivative research, so that license agreement should not controlling over that. So during drafting, you have to categorically mention what you are covering. If you are not open that space, then you are that licensor will going to lose a use in future. The licensee all the time try to open that pathways, but we as a licensor we should all the time try to shut down it, not to open up. It should be shut because only we can give the child continuity because you have to give that, not beyond to that.
So with this, I'll close this session. So, and thank you audience and thank you LexTalk and thank you panelists. So Dr. Bijay, if you can come online. Yeah.
Thank you so much for your session. It was very interactive. I know we have so many doubts. We can clear it later on, of course. As I can see, we all starving now. So we can go and move out for our lunch. But before we step out, there is one more information, or I would say exciting news I would like to share with all of you. That one of our event exhibitors, Provokill, I hope everyone you know about it. So they are giving a huge giveaway that is iPad. It's I would say it's a lucky winner draw sort of. So there is a procedure. You guys have to go there. You have to scan a QR code and register yourself. So I request every one of you, whenever you get a time, please go to their booth and register yourself. And tomorrow they will announce a winner and it might be possible one of you will be a winner tomorrow. So I request everyone, please enjoy your lunch. It's a 60 minutes break. Enjoy and register yourself. Thank you so much. Hello, ladies and gentlemen. Welcome back, everyone, after your lunch break. I hope we all us had a wonderful lunch and an interesting one-on-one informal networking among ourselves. I hope you are enjoying the conference and gaining some valuable insight and building connection with fellow experts. I hope. So, without any further delay, we will begin with our fourth panel discussion session on the topic of data privacy and IP rights, examining the intersection of data privacy regulations and intellectual property rights, and how companies navigate data protection while protecting their innovations. Let's have a big round of applause. To discuss this, I would like to welcome on stage the moderation of panel discussion, Veena Arora, Head of IP Council, SRF Limited, Devesh Bhardwaj, AGC at Bharti Airtel. We have Dr. Praneet Kaur, who's Associate Professor from Indian Society of International Law. And we also have Jyoti Chauhan, who's a Chief Manager of IPR Gujarat Fluorochemical Limited.
Hello. Hi. So thank you, LexTalks, for inviting us for this session, and welcome all of you. After post-lunch session, we'll keep our best, do our best to keep you, awake during the session. I know that would be difficult. So setting the context, in this age of digitization, cutting-edge technologies such as AI, ML, IoT, blockchain, harbor on vast amount of data. Companies like Google, Meta, Amazon, etc., have been accumulating real-world data on every aspect of human life, be it personal, social, financial, and name it, and they have it. The quantity of data is beyond our conception. The data, which is private, an essential element of individuals' autonomy and fundamental to the human rights. An individual engages on the online platforms, digital services, smart devices, their personal data become currency of the digital world. These technologies, on one hand, hold immense promise for the enhancing the various aspects of human life, but they also carry inherent risk on security and privacy of those individuals whose data they are collecting. Individual personal information becomes increasingly susceptible to exploitation, leading to concerns like surveillance, data breaches, and identity thefts. These data breaches mandate a law regulating the access, storage, processing, and use of these data, the private data of the individuals. These regulations can have profound impact on the business and innovation of these companies. Today, we'll be discussing the intersection between the data privacy and the intellectual property rights, and how companies navigate the data protection while protecting their innovation. So before we move on to the real discussion, I would like Devesh, I would like each of my co-panelists to introduce themselves a little more.
Good afternoon, everyone.
Not working.
Good afternoon, everyone. Welcome back after lunch. So thank you so much, moderator, for the brief introduction of the session. So I am Dr. Parineet Kaur, and I work at the Indian Society of International Law, New Delhi. It's just opposite the Supreme Court. And specialized course in IPR, and also our society works in close association with the Ministry of External Affairs and also the IP office. And I have been teaching IP since I think last 8 years, and I have a PhD in copyright and competition laws. And I would like to thank LexTalk for organizing such a contemporary topic. And thank you so much.
Hello everyone, my name is Jyoti Chauhan and I am heading the IPR department of, I'm an in-house IP person in heading IP department in Gujarat Fluorochemicals Limited. So we are a fluorochemical based company. Earlier I have experience of working with a few other in-house as an IP counsel in GSK Pharmaceutical, then Polyplex and various MNCs I was worked with and we few the law firms. So now moving to our topic, like I have 16 years of experience and this topic was a new one. So this was very interesting and exploring the things like how it is. So the topic is, should I start the topic or should I? Okay, just an introduction. Okay, yeah.
Hi, Divesh, will you please give your introduction?
Yeah, sure. I mean, first of all, I'm really amazed to see myself on such a big screen. Thank you, a special thank you for that.
You look good.
Thanks for the compliment. Well, my name is Devesh. I guess it is also appearing on screen and must have been announced. I have 17 years of legal experience. Predominantly, I have worked in-house. I started my career with litigation with law firms, but I think for over 15 years, I've been working as an in-house counsel. I was lucky to work in big corporates like BMW, HSBC, American Express. Currently, I'm working as an associate general counsel at Bharti Airtel Limited and leading the Airtel Digital Limited and Bharti Telemedia Limited, which is a DTH company. Simultaneously, I'm also been taking care of another group company, which is Beetle. So that is currently what I've been, doing in my employment, and I always look forward to participate in these in these events, and just for the learning and contribution purposes. Thank you.
Thank you. Thank you, everybody. So before we move on to the real topic, the discussion about the confusion around data privacy and how the companies will ensure their IP while while these regulations are in place. I would like Devesh, if you can just throw a little light on what is the background of this data privacy.
Thank you, Veena, and thank you for giving me the opportunity to start this conversation. I just heard the word lunch once from you and once from another fellow participants. So let me just try to keep it light, just to make sure that I get attention and also able to convey what I want to speak. Privacy, like any other law, it's a man-made concept. In jungle, everything happens in open. Someone is killing someone, someone is eating someone, and it's all happening in a full private, full public view. I think if I think back and just try to, wonder how privacy was started, I think man has first introduction with privacy when the early men started moving toward caves. It might have been because of some wild animal chasing him or her, or they are undergoing a bad weather. But first time, in my view, the privacy experience would have been in a cave, and initially they might have moved in a bigger cave with a bigger group, and later, everyone started having their families having separate caves and separate huts. So that is how the first introduction with privacy man had. But I think the articulation of this concept, man struggled to articulate till late 1890. And I will just give you an example, like in the 18th century, when Queen's personal letter to the king were published in the newspaper, it was tried as a case of copyright infringement rather than invasion of privacy. The credit of defining what is privacy, what is right to privacy, goes to two lawyers, Louis Brandeis and Samuel Warren. In 1890, they first published a paper in Harvard Law Review in 1890. It was titled as Right to Privacy. It is still available on Google. Anyone can go and read it. That was the first contribution and first articulation of the right to privacy. It really played a crucial role. I mean, even when Supreme Court was pronouncing Putta Swamy judgment in para 34, they discussed about the contribution made by this article in the privacy domain. And just to share, why this was written, because Samuel Warren had a very personal reason to write this article. He was married into an affluent family, and in those days, press was publishing scandals every day. And he also had a gay brother, and he thought, if something wrong is published in any newspaper about his brother, then it can really tarnish or negatively impact his reputation. So this strong need really urged him to articulate a legal basis with which he can defend his brother if anything bad comes up in the press. Now, coming from the history to the current year, I mean, not the current year, last year, we finally had an act after 4 different versions of the various bills which were coming up. I think the first one came out in 2006, and then there was a white paper and Puttaswamy judgment, and we saw many versions. But in my last reading of the act, I think there are 40 plus items on which clarity is yet to be provided. I can see that it has a European soul. There are concepts like data principle, data subject is mentioned as data principle, data controller is mentioned as data privacy. But like any other privacy regulation, it talks about the data collection, consent mechanism, storage, and sharing. So I think that's a good opportunity for all of us. And I think given the size of our population, which is twice the size of entire Europe, I think in the coming years, we'll see a lot of opportunities and challenges when we go forward to implement this legislation as and when it is implemented. Yeah. Thank you.
True. Thank you, Divish, for setting this, the chronological evolution of data privacy along with this historical background. Now moving to Jyoti. Jyoti, if you could just give us an overview of what is this DPDP Act, that was enacted in India last year.
So it is recently came on 11th August 2023. So this is a Digital Personal Data Protection Act which came. So this is very important one, and I am wondering why India is so late, because in US it started, if we will talk about like every individual has some right on his data. So it should be protected in a well manner, and he has very right, like on his whatever the data is submitted to the another person. It can be a company, it can be in any party. So there is a need, like if I'm submitting my data to my company, so I should have a right, like I should provide first consent to the company, like this data I am providing to you, and you will be tackling it in a safe manner, and I can also evaluate like how they will be processing it, how will be safely they are, how it is safe, and I have like the right to information, so I can also cross check that how safe my data is. It is not, it should not be misusing anywhere. And I am also, if I want to modify it, I want to rectify it, so there is a right that I can have that freedom to make it any modification and then resubmit it. And how like no misuse is there, so that type of right every employee should have, and the company should take care of all the steps. And the government has come, like in Modi government again, take the credit of this. And I have heard about, like after this election, after coming this election, our digital personal data protection will be coming into force, and many companies are not following it strictly. I am not knowing why, because their penalty of 250 crore if the company is charged, if any employee makes a complaint or the government find that the company is not following those digital data protection act. Now the people are taking lightly, like in my company also I have taken many steps, like I have consulted the HR head and other person that why you are not taking, and you should take initiatives, because how you are regulating, there should be a consent manager, HR should take consent when he takes when he hire an employee. And also the NDA should be on the place, like you make a NDA with the employee, and when even when the employee exit the company, so at the time of separation you should also take, because the company also provides some data with that, like R&D is going. So how the no misuse is after the join, he will exit from us. So last day we also signed few NDAs agreements, and he will track, like it should not be like he files a patent on the same information with other company. So it should not be there. So we are taking all steps in that direction. And also we are in our company, we are taking steps like no one can take print out without, like who is taking print of what part, no one can, we are using mobiles and emails are there. But in email, you can let me know if I'm okay. So I was just taking like whatever my thinking in easy language, so that everyone who is not aware of this, so that he can take information, because this is recent thing to all of us. So the first, like the manual thing, if I'm taking this print like this paper, so information whatever is written here, it is not taking guarantee of that. But if it is a digitized means it should be in a database, it should be in computer form. Then the act come into play. So that is the first thing. Then our India, it was enacted in earlier, like 2016. There were the government and deliberations were in parliament, and then the reasons were coming like how we should propose. Now finally the draft has come into 2023. That is a very effective thing if it will be implemented after the election as it is proposed by the government. Like in all companies, it will be coming into force. There will be data security and data no misuse would be there. Like the employee data, there are the many information employees submit to a company. Fingerprints are there and many things. So I should give opportunity to. Then I will take to other things.
Thank you, Jyoti, for providing this overview. See, the Data Privacy Act, which has been placed in India, it provides various provisions on consent, the notice to the data principal, the data fiduciary, and a new definition to the significant data fiduciary, and enhanced obligations on the part of data fiduciary. Now, moving on to Parinit, what is, your views on the international issues which are governing this intersection between the data privacy and the IP regulation, IP law, IPR rights?
Thank you so much, moderator. Jyoti ma'am has dealt with the national law, so we are going a little international now. So basically, in the introduction of this session, it was also mentioned that there is a greater reliance on digital technology now, which is ever evolving. And we are using AI, we are using machine learning algorithms. So whenever the reliance on this is more, obviously the intersection between copyright, particularly any IP, but what I am dealing right now is the intersection between copyright and data privacy law will arise. So this tension basically stems from the fact that there are certain rights of the creators which they get from their copyright legislations, and there are data privacy laws which are available to the individuals. So this inherent tension is because of the existence of these rights. So what I'm going to discuss is from the viewpoint of two people. One is the copyright owner and other are the users whose data has been used in an unauthorized manner. So if you see, are there any rights of the copyright owners in case there is infringement of their content on, let's say, digital platforms, and can they demand the data of the users in that sense? So one of the most recent judgment of the Court of Justice of European Union in 2020 named Constantine Films versus YouTube and Google. So what happened in this case was there was unauthorized upload of 2 full-length movies on YouTube. Okay, so the film distributor was a German company, and basically they told YouTube and Google to please give us the names and addresses of these people, the users of the YouTube and Google who have uploaded those movies. So the YouTube gave them certain fictitious names and addresses, which was actually not workable for them, and they asked for additional data. So that was refused by YouTube. Then this case went to the European Court of Justice, and who further said that we will not disclose the data. And it finally reached to the German Supreme Court, the German Federal Supreme Court, who directed the case again back to the European Court, and they asked that whether Article 8 of the enforcement directive of the European Union is there with regards to intellectual property, under which national jurisdictions can actually allow disclosure of information of the users of these digital platforms in case there is a probable infringement of IP. So, but what happened in this case eventually was a very narrow and strict interpretation of the word addresses was given, that if you want to demand addresses, it is only limited to physical address. And in this digital economy and everything, the IP address and the email address was not included. So it was kind of a outdated judgment, because the court actually and the people actually believe that actually a very general interpretation should be given to the word address and not only limited to the physical capacity of address. And so if you see from this judgment, we can see that the right of the users for their data to be secure was given more prominence than a right of a copyright holder. So other case can be where the user's data is used in an unauthorized manner. So if you see recent cases, all of you are aware about ChatGPT, and the company, the owner of the company is OpenAI, and it is subjected to many lawsuits now. So one of the major lawsuits was by an Italian regulator of the data. He said that there was an emergency resolution that no data of the Italian citizen will be collected by ChatGPT and by OpenAI. So they agreed for some time, yeah, okay, we will not collect any data and everything. And they basically said that they had certain problems with the way ChatGPT collects data, the regulator said, and that is with respect to the GDPR, the General Data Protection Act, so regulation. And they said that the data is obviously not accurate and it has no legal basis, and also there is no regulation for people under the age of 13. If they want to use, they can use ChatGPT. So there is no tick box, nothing whenever you're using ChatGPT. So, and also there is no consent from the users for the use of their data, because these AI models, this generative AI, it's based on large language model, which basically a large amount of data is used to train these softwares. So there was no consent, and this was in European Union, and other case was in California. It was a class action because California has the most active data privacy laws. So they also filed a class suit action that obviously they agreed that the use of these softwares, use of artificial intelligence, machine learning, they will help, they will make our lives better, but they should not go beyond that purpose. And recently, Elon Musk has also filed a lawsuit. He was one of the co-founder of ChatGPT, and he has filed a case against the present CEO. So because he said that the motive with which we created this company was not for profit, and now it has shifted the policies to a profitable business. So he doesn't agree. I don't know what is the politics. There are other various narratives why he has filed the lawsuit, but the basic narrative, he is suggesting that the profit, it was for not for profit, and they have shifted its motive of being profitable. So they are suing the company. So what we can do in this situation is, whenever there is intersection between the two laws, for being a copyright owner, I can be more aware of my rights. I can register my work. I can track down my portfolios. I should have a proper enforcement strategy beforehand. And also from a viewpoint of a user of a data or a company which is using, we should have better encryption policies. And we should actually be doing our due diligence and regularly updating our security protocols also. So that's from my side, ma'am. Thank you.
Okay, and there were other terms like GDPR, and Facebook was a famous case in 2018, where the Europe has sent very notices to Facebook, and Facebook has done many revisions into that. Like, we are submitting our data to Facebook, but how much authenticated? Like, anyone can make misuse. And yesterday, I can also recall that it was not working for some time, if anyone can recall. So yeah, there are issues like our GDPR is also working actively. Like if we are trusting on Facebook, so it should it should be safely mannered and safely handled. So that it is taking the action, and there was an Apple and Samsung patent cases, infringement suits also, where the data was leakage was a thing, like data was not handled carefully. So these are the cases our world is taking care of. Like it's our right that it should be handled carefully.
Thank you, Jyoti. Thank you, Parinit. Now, while this, the open AI is either open AI or open space AI, this thing settles. I would like Devesh to please tell us what do you think would be the practical approach that the companies can employ to strike a balance, ensuring the compliance with these provisions?
Thank you, Veena. Well, just to the corporates are in a different scenario right now. Data privacy is coming up, and everyone is thinking how they would have to balance the processing of the data which is there in the organization, has been resting there for over a decade, and balance compliance requirement that shall be put up by the new legislation, and the awareness of the public, which is also developing on this subject. So I think it's all start with by building a culture. You should have your employees should be trained and should understand the privacy related requirement. There has to be, once you have the employee training is done, you should have cross-functional teams. As and when any product is developing, you have people from compliance, legal, product, technology, so that there's a collectiveness of thoughts as and when a product is being started, or you nudge forward, or thoughts are when people started scratching their heads, they had just to come up with any product. You have to have the trained people, you have to have the subject matter expertise, so that the efforts can be channelized in the right direction. The second pillar, which I think is that is the customer. Every corporate would be required to foster trust environment, by having a transparent consent mechanism. So as and when we are taking consent from a customer for data processing purposes, it should be very much transparent, and customers should get idea of where and all this data is going to be used, and that is going to foster and increase the camaraderie between the customers and their corporates. Once you have the entire set processes, there's an education, your customer is also trained, and you need to have regular audits and inspection so that you can identify the gaps, the risk which you can see. There would always be surprises, but I'm sure that if you have a regular audit and inspection, then you can you will be able to 70 to 80%, you'll be able to cut it down on the surprise risk and exposure that may come up. Lastly, what I think is that every privacy professional should collaborate and participate in the industry events, or in gathering with the ministries or the regulators, so that we get to exchange thoughts, we are able to express ourselves, we get to feel like what is going to come up in the coming years. So I think this approach of socializing within the right groups, with the government, with the expert people, shall be very much helpful. Also, when I think that, especially since the generative AI has come into our life, I think it was November 2022 when ChatGPT was launched for public. Since then, everything has been changing, and there has been a lot of data processing happening. And also recently we experienced controversy from Google Gemini. So I think right now everyone is rushing towards, to participate, and everyone is having FOMO regarding generative AI. So I think the companies who are working on these things, they should not only focus on the accuracy, but they should also have some empathy towards, privacy and fairness. And I think if any corporate is going to have a good approach, like, proactive collaboration, going to leverage technology, and going to foster the trust of their consumers, they are going to balance and navigate any challenges that may come up in future. Yeah, that's my view.
So I will be adding in brief, like in my company, I have told first the employee joins, so we make an NDA at the time of joining. Then at the time of exit, there is a separate NDA which we come into place in my company. So that is a company part. So I just wrote ending. So that is a NDA of the separation, like after leaving the company for certain year, he will not leak any information which is provided by the company. And we like for the from the inventors and R&D, in our R&D, no pen drives are allowed, no floppy drive, nothing, no CD. Even the for taking a print, he has to take permission at my plant, like Gujarat Fluorochemicals Limited. And earlier, before this act has come, so there was no so much strictness. But now on my mobile, no print screen function is allowed. And if you want to take print here at my Noida office, so you have a separate, like it will be captured like you have taken print of that information, like from the R&D and other thing. So we are making such protocol like no, and there is no pen drive access in our office. And anyone who is entering, so email he can take, but if he will make a transfer to an external party, he cannot share without HOD permission or anyone, like with the colleagues, if he's sharing, so it is also monitored with the communication cell there. So these are the protocols we are just into planning stage, and we will be implemented strictly after their work. And in our R&D, like you cannot, only the HODs are allowed to take the R&D data and experimental data and other things. No third person is allowed, because there is a user ID encryptions, there are the credential which is only the certain peoples are allowed. So it's not like any fresher can have access to that data.
Good, Jyoti, that the company is taking care of their personal data as well, along with the personal data of the employees. So as Devesh said that, the CFTs are important to impart awareness among the individuals whose data is being collected, and for them to become vigilant of what is the purpose behind the data collection of the data, what is the use of the data, and what if there is any change in the purpose, are they notified, are they going to be notified for the data, the change in the purpose? Now, recently there was in June 2023, the FTC brought an enforcement action against genetic testing company, alleging that the company retroactively altered the privacy policy without properly informing the individual and taking their consent. And the FTC made this company pay huge fines because of that. So here, I want to stress upon the point, the consent as well as the notice of any change, any alteration in the policies of your consent or data management becomes very important. Moving on to Jyoti, we have just touched upon the various aspects of the provisions which are there in the data privacy regulations. Jyoti, would you just, brief us about the special provisions which, either impede or they augment the innovations by the business houses?
Yeah. So there is a section 5 of digital personal data protection, where it discloses the procedures and requirement for taking the consent and notice between data fiduciary and data principal. So data principal is an individual whose data is being processed, and data fiduciary is the entity who is processing the personal data, like the company in our cases. So there is like how the requirement for the data and the procedure, like how it will be taken care of, how it will be processed, and how to exercise the right, and how to file a complaint in the cases it is not properly followed. So that is the section 5 is covering. And section 6 is there, where the characteristics of valid consent is there, like how it should be taken, like it should be easy. If I want to withdraw, like consent at any time, if I feel it is not taken care of in a proper manner, so I can also take that withdrawal, and the consent manager should take care of that. Like I want to withdraw because I'm not having that easy. And the question was like any specific provision which I think like it will be either impede or augment the growth of IP in the time of come. So there are the provisions that could impede or obstruct or hinder or the block the growth of IP. Like if I'm having the R&D, so it should have like it will be followed in a strict consent requirement would be there. So if it would be like, it would be very difficult sometime, like if I don't want, I'm doing a R&D, but I don't want to submit my consent, like I'm on the research stage, I'm not comfortable with that consent. I don't want to sign any contract till it is like I cannot trust on anyone, how much secure it would be. So there are the challenges like for R&D purposes, it is hindering. Like next is the limitation or data transfer. Like if I want to have an external party consultant, technical consultant, or global collaboration, or I want to have an exchange of idea, or so that is like if the act will be passed, so it will be potentially limiting the growth of IP on an international scale. And third is the data minimizing requirement, like how much data should be available for the analysis, how much extent I should be having. So that is the requirement which hindering. And the provision that could augment or expand the growth of IP, like I would have positive aspect, like my data would be confidential. I would have a confidence that it would be secured in a digital platform very in a safe manner and it not be misused anywhere. So that would be the inventor would be secured that okay, I can submit my data with this consent. And there is a right of data subject, like I would have a greater control, like I have a right, like I can be I can track the data, like how much it is mannered, how much it is tracking, how much it is secure. And the compliance incentives are also like in the act, it is given other provisions, like it would be tax benefits and the grant for the commercial way for implementing robust data security measures if it would be. So there are the measures which will be also having a positive impact on IP. So there is like two things. So there should be a balance like between the to protect individual privacy and with the imperative to foster innovation and creativity in digital age. So finding the right balance will be the essential for promoting both data privacy and growth of IP in coming time.
Thank you, Jyoti. Thank you for this insightful, specific, insight on the specific provisions and how the companies will deal with these. Now, I would finally ask Devesh what he thinks is it, the will be the emerging trends or the future considerations in this area of data protection that the companies needs to be mindful of, and while innovating and expanding their digital footprints.
Thank you, Veena. Thank you once again. Thank you for asking this question. Well, I can think of certain, trends that may emerge in the coming future. Some of them have already started, and we may get them in more details in the coming days. The first thing which comes to my mind is that, generative AI that has been creating all the buzz entire the globe. So I think very soon we can expect a regulatory framework. The MIT has been active since the last quarter of the previous calendar year. We started getting some notification from MIT recently. Also, a couple of days back, we had a advisory. So I think the generative AI shall be regulated very soon, or we shall have some kind of binding guidelines. Second thing, I can see that the consumption of data by children is increasingly rapidly. You can see that EdTech is growing. Children are coming, taking their online classes. So I think maybe in DPDPA or beyond that, we may expect stringent regulations that are going to specifically mention how the data belonging to children should be processed, stored, or shared. Third thing, data localization. Any privacy legislation you pick up these days, whether circulated in a draft form or or in a finalized version, you will see the emphasis on the data localization. So in my view, corporate these days are very much particular about where their data shall be stored. The fourth thing that I think is that privacy paradox. All of us have a paradox. At one point we think about keeping our data safe, not sharing it. But as and when we see any cashback offer, let's say even for 10 rupees, we are willing to share everything, our janam patris, about our parents and everything. So these kind of behavior is also going to trigger a lot of complaints, as and when the regulation will kick in. Because we may get some customers who have voluntarily shared their data, but when they realize they were not supposed to do, or they have they can leverage the position of the law. So I think consumer complaints may increase. Yes, the fourth or fifth thing could be is that yes, suddenly there would be increase in demand for people like us. You would be needing to have privacy professional in the organization. So I think these are the trends that I think we may witness in the coming days. And yeah, that's it from my end.
Thank you, Divesh. Recently only there was a case, in the European Union where there was a pay or either pay or agree, These coercive agreements will be there, the consent management of this kind will come into place. And what will be the role of, these regulations and how the companies will navigate through these regulations to protect their innovation? That will be clear in times to come, and it will take a while for things to settle down. So while data privacy regulation will foster innovation, we haven't touched upon various areas where these data protection enactments will actually foster innovations. This will give a platform for the companies to provide solutions which will be, the data privacy, which will be more compliant to the data privacy regulations, like encryptions and anonymization of the data, encryption of the data, and the consent management of the data. So these solutions will be the innovative solutions which will augment the innovation in this direction. On the other hand, there will be which will make these platform more safe and secure by providing different security, cyber security measures such as encryptions that I just said, tools for anonymization, and provide access control to the data principle. However, it remains to be seen how companies prioritize the data ethics and be accountable to the access, use, and accuracy of the data while maintaining the legal rights of the individual. So this confusion will settle in time, and it will take some time to settle down. With this, we close this session, and the floor is open for any questions, please. Yeah, sure.
Reform wishes to all. We do live in a world where data privacy is just a myth. And we can definitely say that European Union is enforcing such things on these companies only because of one thing, that because citizens are well aware of their rights, citizens are well aware of that what the infringement of privacy is. But in a country like India, the Data Protection Act has been enacted upon. But right now, in the ground reality, means what about the awareness which we are having about all these things? Because company will always try to infringe upon the rights. It is completely up to the government. The onus lies only on the government and not on the citizens to just enforce such laws and to make it more enforceable.
See, I can just add on to your concern. See, I was reading a paper that day in which it was clearly indicated that though Europe, they were the first one to enforce these data privacy regulations. But believe me, they have, because of these data privacy regulations, they have lagged behind providing many AI solutions behind US and many other countries. So see, everything comes at a cost. And what we need to decide here is what is the cost behind. If the data, in the morning itself, there was a gentleman, we were having this discussion. He said, see, data privacy, what is it? If you are, if I'm just monitoring, I'm standing outside your house and just monitoring your movement, I'm monitoring what you're ordering from outside, which place you're ordering from. Do you think it will come under your data privacy? So I was I was confused. Does it come under the data privacy? Do we have certain regulations? Then why are we enforcing these regulations on the marketing platforms then? So that is, these are my views. I think Jyoti may differ here. Okay, Jyoti, if you would like to add on.
Yes, so I was saying there was a case in my IT company. So there was our company data. So we have requested like a digital signature or other thing to another party. So they have sent us an email and they have asked, there a click like consent letter. If I will click that yes. So they then and only they will share but with the third party. So, and also the banks are strictly followed, like your any information, if you will ask, like I want to make a that national pension yojana, so Atal scheme and another thing. So they will not do it without having your consent. So they are like it will take time. Like our nation is just waking up. Like in this act, I will say we are already late. So, but the things are moving fastly. So we have booked up and we are moving on the right track in the hospital, and there are the significantly. So they are strictly following. Banks are following. Third party vendors. If you will say like share my information with the bank, and I want to do this, so they will take your consent. So they are following, and we have to take some patience. Like it will be implemented very soon.
See, here we need to be mindful of what do we call as private data. That is what is, if we define this private, the word private, the things, this conundrum will settle soon. Devesh, if you have anything to add on this?
Well, I concur with all the thoughts. Nothing additional to add from my end.
Okay, anybody else? Yes, please.
Good afternoon, ma'am. Thank you so much for such an insightful session and for sharing your experiences and your thoughts on this topic, which is very, very relevant. What I wanted to ask you was that in today's day and age, when we say data is the new oil, and all the companies and every corporate has to mine that new oil and data in order to grow their business, and they protect their data very, very well, though, in all of their airtight contracts and the sensitive information and business plans and all of those things. So when it comes to the data of the customers or the clients, and there has to be a balance that has to be struck with the rights of those clients and their digital privacy rights, their right to not get their private information out there for any other purpose other than what they have consented for. So where does the balance lie, and how difficult is it going to be for the corporates and the companies to ensure that balance? That's my
I would just say, we'll have to wait and watch for this legislation to be enacted and some, case laws to develop. And then, we can dwell upon that precedences which developed during this time. So I would just say that at present, nothing can be said for sure. You cannot say anything for sure. Thanks.
Thank
you. Another thing, like it is a digital, so you should know like anything. I think it is like private, and I am sharing with the customer verbally. There is no proof, so you have to make it digitized. So first part of this is like digital personal data protection. So you have to make it in a database software that way as well.
Yeah, and if I may add something, well, am I Veena? Yeah.
Sure, please, please.
I'm not, present there. So, see, recently there is a report out on last Friday by Bloom Ventures. It's an Indus Valley report, and it talks about, how diverse our country is. So when we say, having a cell phone is also luxury to many people in this country, and this country, we may say that we are 150 crore people, but the actual market size where people are ordering from Zomato, Swiggy, enjoying all the benefits of IoT things, that's a market of only 30 million. So I think we are a very diverse socially and economic basis also. We are a very diverse country. There can't be a straitjacket formula. I'm sure there would be exceptions to the legislation, when we have the welfare schemes like DBT, how the benefit of the technology can be given to the poorest of the poor. How can they be included in this 30 million list? So I think we can't have given a complex and diverse country like us, we can't have a straitjacket formula for all of us. So I'm sure that, as and when we'll progress in our journey of digitization, privacy, we will see. I think it shall be a very inclusive journey and very flexible journey. This is what I think. Yeah.
Thank you. Thank you, everybody.
So this is not a final one. There may be like we will be advising into policymakers, so we will be revising it according to the needs. And there are exceptions within this act, which I was going through. Like if there is a medical extreme emergency, like this person is not conscious, and we have to give his data, so the concerned manager will allow and provide that information. And there are a few exceptions to that.
If there are no more questions, we end this session, and thank you all for being patient listeners here. Thank you.
Thank you, ladies, for such a wonderful knowledge. You shared a lot. And thank you, Devesh, if he's available. Oh, thank you. Thank you so much. Okay, everyone. It's time for our final panel discussion session for the day, which is the last session for the day one of the LexTalk World Global Conference as well, which is on the topic of synergy of intellectual property and artificial intelligence, unlocking opportunities and confronting challenges. To speak on this particular topic, I would like to welcome on stage Dr. Bijay Kumar Sahu, who's a senior manager and head associate editor, Invention Intelligence National Research Development Corporation. And we would like to welcome Dr. Kishore Singh, who's a former UNESCO reporter. Do we have? So I would like to welcome Dr. Kishore Singh, former United Nations Special Reporter on the Right to Education. Please, sir. Oh, I'll check. I request Ms. Vasundhara Prasad to join us. Thank you. Okay, we are also welcoming Ramesh Kumar Verma.
Good afternoon. It's a privilege to be here among you for today's session. And the theme, of course, is very, very important in the modern world for economic development and technological integration and human progress. When we talk of intellectual property rights, we should, I think, bear in mind, first of all, that the system as conceived conventionally centers around human rights. It is with a view to protecting human rights of the creators, artists, scientists, and those engaged in literature to protect their work. And this is very, very clearly reflected in UNESCO's convention, UNESCO's Universal Copyright Convention adopted in 1952 by UNESCO. The idea of that convention was to harmonize legislation and try to ensure that the rights of creators are encouraged and internationally circulated so that the literature, scientific and artistic works are known in uniform fashion, and they created, of course, the logo of which you see in all the copyrighted publications. And then the doctrine evolved to say that computer programs and other types of software, including mobile apps, are protected not as patents but as literary works for copyright purposes because there is a human hand as behind that for creating these works. And the copyright therefore protects the original work of the authorship as such. The creator of the work is the person who obtains the right over the original work, and the question of computer programming therefore is software and application is settled. However, the developments in artificial intelligence, digital technologies and artificial intelligence have been, as we all know, explosive. And today we are living in a world where there is almost everywhere in any sector of social life, personal or economic life, there is indispensable need for resorting to digital technologies. There have been a number of concerns raised on digital technologies in terms of its both the positive, the promises and the perils, because it is a human creation which has become a human monster when it comes to the imagined heights of artificial intelligence. And the challenge before humanity is how to keep upper human hand over the human monster. You must have heard the concern even by the progenitors of artificial intelligence over how it could be a big risk for humanity as such. And therefore, we must take into consideration the fact, as I mentioned, that we are living in a virtual world, but that virtual world could be both virtuous as well as vicious. And therefore, the intellectual property rights, when we try to evolve them to respond to these challenges, must cope with this fostering what is virtuous while trying to minimizing or even putting a ban on what is vicious. I think that this is necessary because the distinction between human-centered creation and machine-centered creation has blurred. Today, it is possible to protect, of course, as I said, human creativity, even if it is neural fashion, That is to say that somebody worked for hire, somebody was hired to work for a company and created some invention or whatever for intellectual property device, and that is protected. But the concern is when the machine themselves become automated way of thinking like human beings, creating like human mind, and because of their big data and other devices, thinking on their own in terms of the property rights. I think there have been a number of concerns about this, and one of the important areas is how we can try to distinguish between the whole arena of conventional intellectual property rights which are protected and then infringement by the big data and all these explosive artificial intelligence developments which are not acceptable when we call of fair use. UNESCO, for example, raised this concern long back, at about 2 years back, in 2022 by Media World Culture Conference, where I read from the text of the declaration that the accessibility and vulnerability of cultural actors, institutions, sites, and markets undermine intrinsic value of culture as a link between people and sources of income, structural impact of digital transformation on society and culture sector affects the culture industry and access to cultural goods and services, and therefore they call for a better system for fair remuneration of artists, cultural professionals, and practitioners so that the system becomes fair, and also raise the concern of the vast inequalities in the concentration of global cultural platforms. I think that is the reality. And this reality is manifest in the fact that there are huge areas of infringement which are implicit, which is very difficult to prove, which are source of what is being created by big digital giants today. And therefore, I would simply suggest for your consideration something like centered around 3 P's for the purpose of developing future-oriented copyright system. This is because we know that, for example, and this is my view, I've been writing about it, the digital technologies, and particularly artificial intelligence, they are inherently, first of all, dehumanizing. There is one book which you must read probably, that is Nicola Carr, who wrote What Does Internet Do to Our Brain? And he said that international shapes the faculty of contemplation and concentration and our very meditative thinking, which is the essence of human intellectual faculty and creation, is undermined. And that is very true because when you stop at the roots of human creativity and intellectual capability by way of artificial devices, then you minimize humanity to that extent. And this dehumanizing impact is more clearly manifested in artificial intelligence when you look at neurotechnologies. Some device can be put in the brain and it can have negative and positive effects. And when Nita Harman from US, she wrote a book, The Battle for Your Brain. That is, say we must save our cognitive liberty and our brain from onslaught of digital technologies and particularly neurotechnologies. And therefore, I think what we need to do is we need to think in terms of, as I said, 3 pronged intellectual property system. One would be we should try to be prescriptive. Prescriptive would mean that governments lay down prescriptions, like it has been the case for the privilege of intellectual property titles and rights. Other part of it could be permissible or non-permissible, depending on the technologies, and finally prohibitive. The certain kind of technologies are not allowed. The permissible use of technology in education, for example, is extremely important as long as virtual does not become vicious, and there have been a number of studies on that. The prohibitive areas are, as I said, hacking and manipulation of thought, voice mimicry, etc., mind control, and the whole or almost doing away with the possibility of one's cognitive liberty. You must have read intellectual property, artificial intelligence and the concern that has been raised with biological or bacteriological weapons and lethal autonomous weapons system. And these are the dangers that I mentioned, and they are particularly considered very important in terms of the national sovereignty, cyber sovereignty particularly, and also the questions relating to terrorism and a number of other issues in that respect. An American president signed a decree in October 2003 aimed at regulating technology, this kind of monster, and I quote, to fulfill the dreams of artificial intelligence and avoid the risk, we must regulate technology. That was his plea. This, therefore, the question of machine learning, machine learning education, all that requires to be prohibited as such. As far as permissible technologies are concerned, I have already given you an example, but we must make a distinction also here in different domains or different dimensions of artificial intelligence and digital devices. For example, when it comes to fintech, industry or finance, we are totally in different world as compared to when it comes to what is known as edutech, the world of education and artificial intelligence and digital devices. You must have also read a lot of concern that has been raised by this chat bot and all that as to how in assessment of students, there is a question of fraud and all kind of other issues, plagiarization and what is not permitted and what could be not even acceptable to introduce. In fact, I believe, and I read a number of articles, that the children right from beginning as regards education should not be induced in totality to depend on tablets and other artificial digital devices. They must have the human touch, play, and what is necessary for building their potential. And therefore, UNESCO called, the United Nations Secretary General called what he called World Summit on Education. And he started with UNESCO. There was a pre-summit held. I was also there September 2022. And the idea was, how do we try as regards education to ensure that the digital transformations do not have any effect which is not acceptable in terms of human rights and many other concerns. And this led to what is known as Gateway in Public Digital Learning Initiative launched by UNESCO and UNICEF, where they said that as far as education is concerned, we should try to rely on the concept of digital technology as common good, which would mean in terms of intellectual property, that there must be by way of either open resources in education, open free licensing or some kind of system, free access and universal access to education resources worldwide, promoted by United Nations and specifically by UNESCO and UNICEF. And I'm trying to give you this dimension, particularly because I think when we think of digital technologies and copyright or intellectual property rights, and particularly artificial intelligence, we must bear in mind the international framework which is evolving. There are a number of declarations which have been made and recommendations. For example, UNESCO made a recommendation on ethics of artificial intelligence in November 2021. And that recommendation clearly lays down the responsibility, social and human responsibility of artificial intelligence companies, big giants, to respect the human rights and all other aspects relating to international law. And the objective of the recommendation are to provide a universal framework of values, principles, and actions to guide states in the formulation of their legislative policy and other instruments relating to artificial intelligence. Similarly, you must have heard also of global partnerships for artificial intelligence, which was a follow-up to the call given by the French President Macron at the Global Forum on Artificial Intelligence for Humanity, and that was the concern, which was organized in Paris in October 2019. And at that summit also, it was recommended to adopt this global framework to support responsible and human-centric development and use of artificial intelligence in a manner consistent with human rights, fundamental freedoms, and our shared democratic values. I quote from that summit, which I mentioned, Global Forum on Artificial Intelligence for Humanity. So I'm sorry if I took long time. I'll just conclude by saying that, as I said in the beginning, and which has been the origin of intellectual property rights, particularly copyright, we must always keep in mind the human-centered approach and how artificial intelligence protected or prohibited by copyright and intellectual property is controlled and regulated in a way to serve humanity and not to destroy humanity, and to try to safeguard the future generations from any kind of encroachment or infringement on their human rights and on their freedom and liberty. Thank you very much. And I'd be very happy if there is a question to give you further information.
Hello, everybody. Let me introduce myself a little bit. That's me. So I'm an attorney in intellectual, I've specialized in intellectual property law, and it's been about 23 years of my practice. Did my master's from New York as a Dean Scholar, worked with an organization known as the World Intellectual Property Organization, United Nations, worked with Amarchand Mangaldas, one of the biggest corporate law firms, then moved in-house with Goldman Sachs, and recently with Cisco Systems, a general counsel for a European major. At present, I'm a practicing counsel in the Supreme Court and Delhi High Court. So this is a very interesting topic because this is still an area which has to be demystified. You really have to understand how the synergy between IP and AI works. Because for IP to be recognized, a human intervention is very important. That's the must, that's the best part of it. IP as such, let me just explain what intellectual property is all about. Intellectual property law is a negative right, all right? It prohibits others to use the creation of idea that you have in terms of patents, copyrights, trademarks, design. So as such, it's a negative right. And AI, for that matter, is human intelligence exhibited by machines. That's the language. That's the definition of AI. So on the face of it, AI cannot be looked at as a patent holder, because a lot of cases have been coming up in the US. I think the Southern District of California just looked at a case where a patent infringement matter was filed by Qualcomm against Apple, where it said Qualcomm sued Apple for infringing upon its patent. When Apple looked at the whole matter and it went to court and it said, no, I'm not infringed on their particular patent because this was a patent that was created by an AI, all right? So that's not a human inventive step that has taken place. After a long discussion in the court decided that because it was a part of a patent which was created by human, this can be also looped in, and Apple had to pay a lot of sum to Qualcomm for infringing the patent. So understanding intellectual property law and understanding how IA is going to define it, or how IA is going to, in some ways, aid to intellectual property law. Patent, just going through the definition of patents, be it the USPTO, be it the EPO, which is the the European Patent Office, or be it the Indian Patent Office. We have a specific regulation where it says that human inventiveness is very important. That it has to be created by human. So this is a scenario which will create a lot of issues, because a lot of technology or a lot of algorithms are being created by AI, which does not have in any way human interaction or human intervention. So who is going to get the patent for it? So that's still okay. That's still a scenario which has to be looked at. The second scenario is the copyright issues. There are so many copyright copyright infringement matters which are going on. Take, for example, the Cambridge Analytica, the famous Facebook case, where a lot of information was shared without seeking consent from any of us. So those are the areas where a lot of data mining goes in. So a lot of data is being used without consent. And if original copyright is being created, who is the author of that copyright? Who owns the copyright? Because can a machine own that copyright? No, it can't. So who owns it? That has to be demystified. So going through that definition, an engineer or a data mining expert, will he hold that copyright? Because even though he's not done anything for it, but it still fed the information to the computer for doing that. Then there are issues with regard to design. I think there's a lot of original designs that are coming in very recently. When we talk about NFTs, that's the non-fungible tokens, which are copyrightable in some scenario. So these are issues which still have to be looked at. There's still no clarity. As lawyers, we still don't have any clarity because the courts still are working on it. So there's a synergy, there's a positive, these are the negative synergies, but the positive synergy is that it's really helping, AI is really helping intellectual property grow in a scenario that it's making work easier for attorneys. You have a lot of documentation which are done by AI in a span of 1 hour. If you give it to someone else, if you give it to a particular contracting agency, or if you give it to a particular paralegal to do it, maybe they'll take a month to do the same work. So AI is certainly complementing in certain scenarios. Other than that, it's certainly helping a lot of individuals to manage work by their own. So there's certain amount there's certain synergy that goes in, which is a positive synergy, but on the other hand, there are some negatives to it, because intellectual property right is a creation of mind. If a mind cannot be attributed to a machine, so that's extremely important. The last aspect that I would like to talk about is the open software, or the open the part where we're talking about open source software. Open source software does lead to a lot of issues with regard to open source for the benefit of the society. That's what open source is. I mean, if you use the algorithm and you create your own program out of it, you need to give credit to the open source from where you've taken it. But in AI, it's very difficult to attribute that. It's very difficult to attribute that you've used that particular open source algorithm and there is commercial value to it. So these are the areas where it still needs to be addressed. There are few issues which are being addressed in the European courts or in the US courts. In India, it's still the nascent stage, but we'll be adopting the rules of the DPA very, I mean, in a span of certain months. Once that comes into place and the rules come into place, the judges will have to train themselves and the lawyers have to do a lot of precedent hunting so that they can present that in front of the judges. That's about it. If you have any questions specifically with regard to this, I'll be very happy to answer them. All right, thank you.
So thank you. I'll go next. So I'll share an example of how AI is helping in IP. So recently, one of our patent application in US, we got a rejection. So this patent application was filed in various other jurisdictions, Canada, Europe, and some other in China, India, Japan. So this patent has been granted in most of the geographies. And in US, we got a office objection citing a prior art document, which says based on that, he cited that it's a non-obvious. So invention is non-obvious. So what my attorney did, he shared me a PDF document generated from an AI tool about the examiner. So his profile, what he has been doing, what kind of objections he has been raising. So from his history, we came to know that it's around 40, his grant rate is 45%, and the kind of document he has cited, it's a very clearly written document which says that everything can be made by all the permutation combination. But when they gave an example, it's citing that these are the challenges, and to solve this, this is what you can do. So what document is teaching is totally different what they have written, explained in their descriptions. So, but examiner has cited it. And from that AI reports came out very clearly that after what stage and what are the considerations examiner has taken for the granting patent. So one thing was very clear that he relied on the experimental data, not on any argument. So for us as a tool to protect our own IP, this AI tool is very helpful that at least now we understand that we have to make a submission, so we have to rely on the kind of evidence we have disclosed in the patent application and what additional scientific evidence we have, what document is teaching and what actually happens, so that examiner takes into consideration. This is one of the positive thing what AI can help us in protecting our own IP. Other than now people are coming and saying that yes, they can get an idea and whole invention and file a patent application. So sometimes it sounds very weird to me, because if you go for a real patenting process, actually the field I come from, you cannot get a patent just by what you get an idea, you get a theory. But to get a patent, you need to have a best mode of working an invention. So it's your AI tool is not going to give you mode of invention work best mode, so experimental data evidence that you have carried out. So yes, but what is going to help us? It's going to help us in the accelerating our innovation process. So if you take the drug discovery process, so mostly the drug discovery process has heavily relied on the in silico, means based on the computer using computer tools, so algorithm and all those things. So because there are hundreds of compounds and molecules which can target a particular receptor, so they heavily rely on that. So in that process, I think it's going to play a major role and going to help speed up the drug discovery process. And there are various other tools like new era of gut microbiome, so their prediction of the AI tool may be helpful. But at the same time, we see that use of AI for other human purposes, so there is a lot of concerns, a lot of debate, and other use of data which AI is using for training itself and getting their own benefits, so that IP concern is there. So recently there was a question to the Union Minister of State of Commerce and Industry, Sri Som Prakash. So in Rajya Sabha, so he gave a written reply to that. Somebody asked that whether are we going to create a new form of IP to protecting the give artificial intelligence protection. So he gave a reply that our Copyright Act per se protects the AI related inventions generated by AI. So any exemption has to be there. So that has to be there as per section 32 of the Copyright Act. So I think for us at present, I think that's a very good guidance and understanding that if AI is generating something, what it holds the value, whether it can be somebody can say that he should get AI should be an inventor or not, because your Section 32 of Copyright Act talks about the exemptions. So what are the exemptions are available in the Copyright Act? So it means whatever AI is giving us, it's an exemption. It's as per Minister's reply, it's an exemption. That's what we need to consider. Beyond that, AI has to have a license from using the data. Yeah. So that's my take on that particular from that reply. And challenges, I think that challenges, biases, and all those things going to, if you use two different AI tool for the same query, you will get two different replies. So that biases are there. So which one is correct, which one is not? So that human ingenuity and judgment is going to play a role. So that's going to continue. There's no question about it. And data privacy, it's that in previous session, I think it was discussed in much detail that what is personal data and what privacy we should have, whether it's really there going to be privacy or not. So that's also evolving area. And with this, I would like to end my talk. So if anything else is there, if somebody like to ask any questions or any
question for the later industry. Like soon there has been protest in the US that US filmmakers and heroes are protesting that AI is going to replace them, right? The similar question that how are we going to form a foundation for it? Like very soon, like for example, James Bond, he will maybe he will die, but after 50 years of time, we can use him for the next 200 years of time, right? So who is going to lay down the foundation of these new emerging areas in the creator industry? And the second thing for that NFT as well. Right now, some celebrities are experimenting with NFTs. They are going to voicing their voice. There are some of the photos and all sorts of things. But what should be the benchmark or the foundation for it? Yeah.
All right.
And then another question was that there would be from the smart contracts that I will going to ask from the blockchain thing. But once we'll have smart contracts in a very full-fledged way. Right now, it's on the nascent stage since last 6 years. With time, it will get evolved. And I'm very much promising towards that. That after 5 years or 10 years of time, we would be not be needing so many number of tribunals or arbitrators. The smart contracts will itself has so many detailed clauses, so many detailed things regarding payments. Also, we can that will have its own escrow account, and according to the clauses, it will get executed. So, I'm asking for the future perspective? Are we going to reach that, or it's just a kind of speculation?
All right. Thank you for the 3 questions. All right. They're good questions to understand for everybody out here. First question you asked about the actors and being replaced by machines. That is going to happen. That's only, a frame of time where that's the main concern that most of the present so-called thinkers, the billionaires, are thinking about. That machine is going to replace humans, and that will happen in a scenario of time. Yeah, so that's the reason. That's how intellectual property comes into being, and that's the talk that I made earlier, was that intellectual property specifically gives credit to human mind and human creativity. We cannot give creativity, we cannot address the same aspect of creativity with non-humans. So machines, they don't have creative sense. We are humans are providing them with data in order to come out with the whole, algorithm or their own synergy. So for creativity being, the credit of creativity being given to machines will never happen. So that's something that intellectual property addresses. It's still in the nascent stage of addressing it. European Union has come up with a draft. The implementation is going to happen. So is the implementation in India going to happen. So are we going to have a separate law which takes care of artificial intelligence, or are we going to juxtapose that with the present Personal Data Privacy Act? So that's a scenario that we are going to talk about. The NFTs. NFTs still pose a lot of difficulty because NFT can be replicated very often. Anybody can generate the NFTs. If I've looked at a picture, I can right-click it and generate my own NFT. So that's a scenario which still it's still in the nascent stage. So if I have an NFT and if I'm selling it to you, who holds the copyright for it? That's something that has been debated quite often. The copyright is still with me because I'm the author of the NFT. So if you go to court for it, even the court will have difficulty in addressing it. So that's a scenario where you have to address how the copyright is transferred. Am I transferring the full copyright to you, or I'm keeping the copyright for myself? So that's the answer to most of your questions. The last question of smart contracting. Yes, this fully automated. Yes, and that's happening. That's very much happening. The previous organization that I worked with was Cisco Systems, and that was highly technology driven. So as a lawyer, I did not have to hire a large team to do a lot of the contracting issues or the Delta V issues where I'm looking at a contract which had gone on for past 10 years, and I'm not aware of it because I wasn't there 10 years back. But just because of the AI centric, I was able to look at it and I was able to compare it so that I don't have any issues when there's a merger and acquisition going on, when there's due diligence being looked at, because that's this due diligence poses a lot of questions. If you're going for an acquisition, I think due diligence, and that's where AI helps, because AI will counter all those issues that may come up during litigation. So that is certainly a helpful scenario with AI. All right.
Maybe
Sure.
I can add.
Yeah, sure.
If you allow me, I'll just add one remark. I think that, as I mentioned already, the question is, I mentioned about UNESCO, but in European Union, you mentioned about US, European Union, there is a huge agitation almost among the cultural art, cinema, film, music, etc. workers, and the violation of their intellectual property rights by big tech giants. And for this, that European Union adopted Digital Services Act last year, which I had mentioned. As far as US is concerned, there is a case I would like to cite where the US court said, I quote, "Work created in absence of any human involvement is ineligible for copyright protection," stating, and the court stated, this is very important, I think, idea, quote, "Human authorship is bedrock of copyright requirements." So I would like to put a question to you and make one more remark. The question is, of course, the automated system of machines is human creation, but also machines created. We read a lot about how quickly chatbot can, this artificial intelligence can summarize all your emails, create anything. And if you imagine in a very fast-paced manner, I would say you just have to push as somebody wrote an article, just push the button and you get whatever you need in terms of putting together an essay. You can, there have been instances of writing poems and painting copied and all that. So there is a huge scope of digital devices working because it is rational and methodological in terms of data that is fed for being as much productive in technology as human mind, even faster. Because if you look into artificial intelligence, the way it's happening, that is why it's used in the business and finance, is much more attractive than in other areas. But then the question is, what happens about infringement of intellectual property rights of many other right holders in the past whose proprietary rights were misappropriated by these big firms. I will quote the developments. For example, the largest issue is that of infringement which occurs when, and that is why we call it generative artificial intelligence, that it generates large language models and various ways in which they are, in terms of intellectual and rational thinking, even far ahead than human beings. And therefore, the generative artificial intelligence is trained, but what is the base of technical development? That is the training or used by popular deep learning models, which are generally trained on a very large database of media. And that is why this training, this kind of training by database as such, generates vast quantity of pre-existing human authored works, that is intellectual property protected works, and use inferences from training to generate machine learned ideas. Result is, since the process of assembling training data by these big artificial intelligence devices involves making copies of copyright works, it may violate the copyright holder's exclusive right to control the reproduction of their work unless the use is covered by exceptions under a given jurisdiction. And I think that is the issue to which there doesn't seem to be, to my mind, yet an answer. People are thinking about. But one question I'll put by concluding, on which you can reflect if you want. I at least find it very intriguing. The question is, imagining that machine created intelligent software, created something which is artificial, totally artificial, and copyright claims are made. Who will be the claimant? Whose rights will be protected? As I said, it will be employer, neural work. But if you look into intellectual property right, you create a right, you are right holder, and you have a right to defend yourself in case of infringement or encroachment. Now, there has to be somebody, something, natural person is supposed to be the person who is right holder of intellectual property. But even if you were to assume that it will be moral person, the question finally boils down to the fact that it is the companies which will be claiming on behalf of their work the proprietorship or ownership, because there cannot be another solution. So when you file intellectual property claims, all procedures, you have to mention who is the author and originality and all those criteria. And the author, of course, is the company which employed the people to create assets.
I think I'd like to address the last question, what you want to wonder who will be because there are debates across different courts.
Sorry, can I interrupt? But I don't know if it's good. I'm sorry to interrupt. What I wanted to say was, assuming that a machine is allowed to, how will machine register? And how will machine claim?
I think that is a universal problem. Like in the COVID, there was a global problem, and the global cooperation happened. Then only normally vaccine used to take 8 to 10 years of time. All of us, due to global cooperation, shared our data. We developed across the world within 8 to 10 months or 12 months of time. So similarly, I think in the space of either space, in the field of either space or AI, I think like in the human rights, we have UN declaration, and then according to it, all of the countries are adopting their own law. So I think United Nations or all of the countries must having a common convention regarding AI. It is need of the hour. Then only we will be able to afford, because this is transboundary. Because one company sitting in India is making product for a boy in Chile, and he is generating some intellectual property listing. If we don't have the common laws, then it will be a huge problem for all of us of the different courts of the different
That's. Can you hear me? Okay, that's great. That's a good point, and that's a point that's being pondered upon at present. The World Intellectual Property Organization is having a lot of discussion with the member states
And the member states are all of us. So all India, US, UK, every member of the WIPO is coming up with their own white paper, and they're trying to synergize the AI and the IP, the scenario where we have a common legislation, like the World Intellectual Property has a specific legislation of copyright treaty. So everybody who's a member and who signed the treaty is part of that. So nobody can violate it, and it does lead to reciprocity.
So is that conventional knowledge?
That's the conventional knowledge. That's the conventional knowledge. But as he rightly pointed out, that in terms of, if an IA has created a copyright or a patent, who claims it and who files an infringement claim against? So the employer definitely will do that, and because the AI does not have a legal standing in the court of law. Only the employer will have the legal standing in the court of law to represent that and to say that this is the IA that has been generated. Firstly, for the courts to address that, firstly, they have to recognize that it's not firstly, they have to make sure that it's a human intervention that has gone in to generate that. If it's not, then they have to make sure that there is some kind of inventiveness that has gone in to generate that. So those are the scenarios that, yeah, sure, go ahead.
So I teach in my university's National University of Singapore. Here at in Bangalore. My question is, a lot of people between automation and AI. See, for example, a lot of people confuse between automation and AI. Automation is an evolution process. AI is just the creative aspect that it can substitute for certain things and maybe do it better. I'm not so sure it's a bad thing, because it is almost evolution of the next generation. If we had a next generation who was smarter or was dumber, would that be, that's just part of evolution, right? And secondly, it's like the laundry machine. It frees up a lot of time to do other things. So this technology is not even developed in one place. It's developed, distributed across. So why are we even, instead of enabling an ecosystem and seeing how it evolves, because you're not going to reinvent the wheel, it's going to evolve, take its own course. It's like nature. So why are we not letting nature take its course? And maybe we are looking at ethics of AI and a policy of AI, really. I think the philosophy of those creating the AI is more subject to study and research rather than the technology itself, because technology per se is neutral. It's the development, is the usage of it. I mean, it didn't stop Einstein or Oppenheimer, so why would it stop an Altman or Musk? I'm saying that it has to evolve over time, and we have to take a generational view, not a generative view, but we have to take a longer term view of this, because if we stymie it too much, then it just cuts off something which could improve things for a later generation, and we are not the custodians of that. We're just trustees on this planet. Same with environment. A lot of technology and environment go together. A lot of AI could enable that environment. So who is going to balance all this? Because as we say in technology, what is the use case really? Who is the end user? The use cases could be multiple, but the source of technology is so amorphous right now, so global in its nature. So what are we even talking about at this point? Where is the policy and what is this ecosystem? So to map it, won't it take time? And do we not have to take a researcher's point of view also into account, because use cases could be multiple? Thank you.
I think you rightly pointed out. So most of the debate is happening not around what you're saying. It's around happening. People are talking about saying that AI is using a lot of data. So what they have developed, there is no question about it. Nobody is questioning on that. But to train that, lot of people's data, other people's, everyone's data goes in that. So when you say data, end of the day, companies make money. So it's not, they have not created for humanity, for charity, to make money. So everybody wants their piece of cake in that. So it's all about that. So nothing bad. So
Voice people make money, but somebody at some point will generate the wealth. So the new wealth creation will come from somewhere.
Yeah.
Not this and something else.
yeah, so everybody's saying that if AI is using my data, so what is it? Because data has been, your data has been allowed somebody to use for as the copyright section 32 of the Copyright Act. So it's as an exception. So for your personal use, if somebody, so copyright says that if you are using it for commercial purposes, you should take a license. So, but AI doesn't take any license from anyone.
But it's also enabling us, it's also flowing back to it, it's like environment. Humans don't pay the planet or the environment, but we're also sort of substituting planting trees. It's a two-way process.
In environment, I'll let you, there is a,
The logic of it.
there is an act called Biological Diversity Act. So there is a protocol called, it's called the Nagoya Protocol. It says access and benefit sharing. If you are accessing any biological resource, you are supposed to take a benefit sharing. So I think it's the same concept people are trying in AI. If I'm not wrong, it's my take.
Sure. Do you have a question? Go ahead.
Yes. Also, I don't think the debate here is about whether AI should exist or not. It already does exist. I think the debate is more about how the law can catch up and how IP can catch up to actually make way and make space for AI, right? To regulate AI. Correct. I think this is more a comment than a question, but I'd love to get your thoughts. And I think Sir touched upon it a little bit. But recently, there's also been a debate in terms of recreating, say, a famous singer, for example, S.P. Balasubramaniam, who's a very famous South Indian singer. He's passed away in 2020, and then his voice was recreated for a song by a Telugu filmmaker, if I'm not wrong. And obviously, the family took offense. And they sent a legal notice, and they sent a legal notice more from the perspective of wanting to give permission, right? And getting consent and compensation and things like that. But in terms of how this plays into, say, something like publicity rights, because actors like Amitabh Bachchan and Anil Kapoor have filed case laws to get recognized in terms of their voice, their image, their name, their likeness, which cannot be used without their consent, right? So in a situation like this, in today's time, when AI can be used to recreate these rights, I think the interplay of publicity rights, IP, AI has more prominence. And then the question is, whose permission do you need? Who owns the ultimate IP when such songs are created or anything along these lines? I would love to get your thoughts on how you see this playing out.
You want to go?
No, I fully agree with you. I think that is the issue. And as I have already mentioned, I agree. And I think that is the issue, that it is because of this big data and the resources the big companies have, digital giants have, they have huge amount. It's all a question of your data and cloud computing. So that you, on the one hand, you are in terms of data, which is considered to be well today the richest, and on the other hand, you are practically outside purview of any state or authority, because it is question of what is virtual, what is in the cloud. And therefore, the questions that you raised, I agree with that. I think personally that the only solution would be if, and that is practically, I think at the present unimaginable, there were to be some supernatural international understanding and agreement with a convention to trying to defend some concepts which are floating from United Nations, such as digital commons. Now, how do you give shape to digital commons in terms of practical uses, but also in terms of intellectual property right? Then the whole concept of intellectual property right in the beginning at least was dissemination and international cooperation. How do you try to match the developments in artificial intelligence with some kind of international cooperation? That is the main issue between European Union and United States on the one hand, and between China and United States on the other. Because you have big poles of technical potential and growth, they are flourishing in their own ways, and there is hardly anybody capable of controlling. Most unfortunately, because the states as such are absolutely of no consequence, most of them, in front of these digital giants as such. And there's a lot of literature on that. So what should happen is building upon this concept of digital common goods, which has been given, some kind of convention could be formulated. UNESCO organized in 2023, last year, a big meeting to reflect over these issues and try to see how we can create a kind of intellectual property system under the aegis of United Nations and UNESCO, which would protect the copyrights as being which exist and other copyrights which should be necessarily based, have their foundation in human intervention, human thinking, vis-a-vis anything which is artificial. And that I think is very difficult question, but probably this will be the only way. Otherwise, I don't see any solution if it is left to states as such. To me? Yeah. Sorry, I am not in, I founded Right to Education program in UNESCO and later on in United Nations, but I had some interest in intellectual property rights, so I'll try to, please sit down. Please sit.
I would like to ask you, like you've been talking about protecting copyrights.
Yes.
When artificial intelligence is creating, like somebody is talking about actors' rights and all those.
So how do we create a balance and maintain a balance? Because we know there are countries, including India, where cloning is not allowed.
Slowly?
Cloning.
Yes.
So how do we have a balance between having artificial intelligence into developing like voices and other things and creators' activities, and then also considering and maintaining the ethics about cloning? How do we have a balance between the two?
I do not know. Only answer I can give is what was already given by Anushka and others, that we need to think, because of devastating impact, possible impact of artificial intelligence on humanity, we need to have some kind of treaty, as idea was floated, like nuclear test ban treaty. You discover, you know the story of Oppenheimer, who had absolute power in the US before World War II. To invent nuclear bomb, it was invented, exploded, and when it was exploded, there is also film which has come. He immediately had ethical concern and said, absolutely, I made the biggest mistake of my life. Please do not ever use it again. And the US government said, it's our business, not your business, to use or not use. Now, that went on. But then the nuclear test ban treaty came. Today, there are many countries, including India, which are nuclear power, but this in practice still is, apart from deterrent, doesn't have much of value as such. Although it is, the stockpiles are there. And therefore, what I would like to say is that there could be some kind of ban on artificial intelligence when it comes to, as you said, cooling, etc., and other issues, but also the weapons that I mentioned, lethal weapons or bacteriological weapons, which are destructive of humanity. In other words, the guiding principle is same as I've had. When the technologies are promising, you foster them by way of some regime, but when they are vicious or even dehumanizing and the consequences which are a threat to humanity, then you must try to, humanity should. There is a very great writer, I don't know if you must read, maybe Edgar Morin. He's French, and I know him, and he had been writing a lot. He's a very great intellectual thinker. He wrote recently a book on crisis of humanity, and he said that many crises, including these technologies, artificial intelligence and others, and we are living in a world which is heavily laden by big, he called multiple crises, where humanity, I'm quoting from the essence, humanity does not know, humanity with S, small s, humanity does not know how to become humanity, double, capital H. I think that is the issue, that we have to be human and then have a concept of humanity, Vasudeva Kutunga, whatever concepts are floating here, there could be an element in that. But the important thing is what is at stake for humanity? How humanity, under the aegis of some institutional framework like UN, could stand up to defend their own welfare, their own democratic values and other human values which are defended by human rights. I think that would be the only possible way. And that's something for which all governments and we all actors and other stakeholders should work. Thank you.
All right. Thanks for all the questions. I think they're fantastic questions. All right, can I just answer her a little bit? It's a wild west at present. The AI has created a wild west in terms of there is no legislation, and as Sir pointed out, the specificity of having one particular legislation for all the member states. That's what the scenario is in give it another 2 years or something, because when I was reading through the white papers that are coming up, they're still synergizing the whole scenario, and maybe in a span of about a year or two, we'll have a composite legislation where all the member states sign it and become a party to it. Just adding to it, there's a dichotomy in terms of understanding intellectual property law, because if you're looking at public good, AI does have a lot of public good. But then if you don't have a balance between public good and the evil that goes in, there are a lot of infringement matters. But like for us, I mean, for India, for that matter, if you say that most of our intellectual capital was never under the patent regime. So most of our, I'm talking about the earlier ages, where you're talking about the ancient ages, the Vedic ages, which was the richest part of it, because we believed in public good, and that's the reason. The Western countries did not believe in public good that much. They believed in the commercial aspect of it. They wanted to commercialize it. So if you don't have the commercial aspect attached to it, a lot of times public good does not help you. So it's a balance. In India, we believe in public good. We believe in compulsory licensing, which is very good, but the West does not believe in it. So to keep up with the West, you need to have a strong regime which kind of provides you a guardrail in terms of intellectual property, but also in terms of adapting IA into intellectual property regime. Answering cloning, all right, yes, we don't have, there's restriction of cloning, the stem cell cloning. But just looking at the legislation that goes in, even in the US, there is cloning happening very often. How at this point of time, the world effect is that if you have therapeutic cloning, then that's perfectly fine. That's within the ambit of doing public good. But reproductive cloning is where it becomes a very evil area, because a lot of things can go wrong in that, which even the scientists cannot predict. And we as lawyers cannot predict that, because that may happen. So therapeutic cloning is definitely good for us and good for the community. So that's definitely a positive sign. Yes.
The concern of 140 crores Indians, because I'm not aware regarding the solution of it. That's why that's a genuine concern. What we have analyzed, there are three sub points of it, and then my question is that the concern regarding that. Recently only, we have seen that more than 100 plus top AI researchers around the world, few months back, have told the world that please stop using whatever the artificial intelligence based research is going around the world. So many prominent researchers have put that. The second sub note is that the merger of information technology and the biotechnology is going to be very cautious if we are not going to the delves into it. And the third point is that the big tech giants, normally they are in themselves a supernatural country. They have that large size, that huge influence. And they don't even tell government at what capacities they are running the technology. They inform that we are at the basic stage, let us say delta stage. Even they have reached to the gamma stage then also. These are the three basic subnodes. And my concern is that what as a common citizen of India or any common society can do, whether we can file a PIL in the Supreme Court, because the law and policy is not going to the pace at which technology is going. So that's the concern, whether we can file a PIL regarding this, or whether Supreme Court can take a suo motu decision over it. There should be a committee or a body, a government-based body who should have, because the previous below 2000 years from now, since last 2000 years, we didn't have this scenario ever in our life. This is the first time when huge amount of data is flourishing in the world, huge amount of tech capabilities is happening, and the commercial point around the world is at the peak. So who are the commercial giants? They are going to reap benefit out of it. But if we don't have any such kind of committee or any such kind of things within our country, then it's going to be a matter of concern in next few years. Because if right now we'll miss the bus, I don't know what will happen. Yeah. So that's the concern, please.
All right. Do you want to answer?
You are the right.
All right. All right. All right. So that's interesting, and that's very much true in terms of there's still no when the World Wide Web came into existence in the early 90s, people didn't know what's going to happen. We only had a very minuscule idea of what is going to happen. It's only when Google became a verb, Google is pretty much a verb now. So that's when we really understood what the World Wide Web can do. Because earlier, World Wide Web was only used for, specific knowledge gathering between countries. So if I have a specific security concern, I'll ask the specific country, all right, can you send it across? But now it's become like a giant library. You can do anything and everything with the World Wide Web. And that's the same scenario with IA because it's the nascent stage. But when OpenIA, when the inventors, of the founders of OpenIA or Elon Musk or any of these big giants talk about IA and it's generating commercial value, but also keep the guardrails. I mean, it's very important to understand that at this stage or at this 2023, we cannot really, we cannot foresee what's going to happen in the next 10 years. And that it's very difficult to imagine that because there's still scientists at at DARPA, which is an organization in the US, they're still trying to understand it and what's the capability of AI. So before that, when you asked the question of having a PIL in the Supreme Court, well, that's too early at this point of time. Let the DPDPA come into existence and then see how it's going to let the rules come into existence and let's see how it goes forward. Let's have some precedents in. And the Supreme Court maybe in some time will come up with a very standalone, precedents, which kind of gives you a guardrail, like we had the Aadhaar case, which Puttaswamy, where it did give a guardrail as to privacy is the innate, it's it's an innate conscious, or it's something that's innately inherent in our constitution. So maybe we'll have a precedent down the line, maybe give it another 2 to 5 years. We'll have a precedent which kind of gives you a guardrail for the next 10 years to come up. Any other questions or we'll close the seminar? All right. I think that's the end of the questions. Thank you for your questions. You're a very lively audience. Thank you.
Thank you so much for your knowledge, sharing your knowledge.
Okay, everyone, we come to the end of the day one of the LexTalk World Conference. I hope you guys enjoyed. Of course, I saw the interaction, debate, what happened here. I really enjoyed it, though I did not understand a bit, but yes, I really enjoyed it. So I would like to inform you everyone that tea and snacks are available here. I request you guys to please help yourself and we will see you tomorrow. Till then, have a great evening and enjoy your day. Thanks.
Thank you.
यार दूसरे के बाद दूसरे में देखेंगे लाइन डाल यहाँ इनपुट आउटपुट दोनों यही से लेंगे और साउंड का भी इशू लगा देते हैं कौन सी ये उठाओ ये पकड़ो ये शट डाउन करो लीव मीटिंग कर दे रहा भाई